Yesterday last day. There was also personal appearance. So can they take up the matter also after vacation immediately?
Take a date from
50th of January. Oblige.
Item 18 of the submitting here, carry the matter maybe takes up the new variation.
Nice. Your good name? Member, learned counsel for the petition or with consent from the other side, first for listing the matter after the application. As the conducting counsel has some inconvenience today. Parallel races unless the matter after vacation.
Item 7, my lord. It is part of my lord. So
Yes.
Mr. R.P. Sharma is appearing, but he has some medical problem today. R.P. Sharma. So may I pray it may be taken on 8th of January.
On the prayer being made by Mr. Rosid, learned counsel for the petitioner, races unless the matter after vacation on 8th
Yes.
of January.
8th of January.
Okay. Yes.
I have not received the complete instruction. So the matter may be listed after due vacation.
Mr. Kayum, learned counsel for the petitioner, with consent from the other side, press for listing the matter after vacation as he has not received the instruction. Where allowed, races unless the matter after vacation.
May I please, your lordship. Lordship, a matter was fixed yesterday, but it was not, court was not seated, lordship. Maybe taken on tomorrow, your lordships.
Is there any urgency?
Yes, lordship, a physically challenged teacher was transferred to another place, your lordship. That's
Okay. Okay.
Wonderful.
on tomorrow,
Yeah.
lordship.
I beg to mention item number
Deep
20.
level.
Item number?
20. Lordship, this matter will be taken up after the winter vacation. I will inform the other side also.
Mr.
As taken.
As Deka, learned counsel for the petitioner with consent from the other side, press for listing the matter after vacation. Where allowed.
Okay.
May I please, lordship, my lord, one matter, my lord, was listed yesterday, my lord. Your lordship was not sitting, so mention was made for listing today itself, my lord, that has not been listed, my lord. Urgency is there, my lord, kindly tomorrow, because it is for resume classes, my lord.
Pardon?
It is for resume classes, my lord. I have not been allowed to attend my classes.
Correct. Tomorrow.
Lord, it is very urgent, madam. Because already my mention was allowed,
Okay.
my lord, for today, my lord, but that has not been listed, my lord.
Yes, yes.
And my lord, another, my lord, prayer, my lord, in item number 23, my lord, one affidavit in reply has been filed today, my lord, that should be brought into record. Obliged.
Not on matter, my lord, urgency is there. May I pray for listing immediately after reopening the court, my lord,
Take a date.
on 8th or 9th, my lord.
All right.
Obliged.
Item for withdrawal. Item number 31.
I have objection in this case, because there is order passed by this honorable court. The last local is an earlier order. Then earlier order, this honorable court, they agreed that their 50% will be paid to the second wife. This court passed an order. The last file is the earlier order. And then when the matter was listed on 9, court pressurized them that you make the payment as per the agreement you made. They took 2 days time, my lord, from the court, my lord. Now they filed a petition for withdrawal, my lord, misleading the court, my lord. The last file is the earlier order, my lord. Order that 9, then earlier order. Then noted here. This one could pass an order. They make a statement in the court that we are paid 50% of the amount. Private respondent. And matter was listed on 9. On that the court asked them to make the payment. They take 2 days time, my lord. 2 days time. Now they file a petition for withdrawal, my lord. That time has already been over, my lord. Withdrawal has already been over. And when the pension and the benefit has been allowed, the hearing was taken place by the authority. And they make a statement before the authority that we will pay 50%, then pension amount has been released in their account. After receiving the account, they violated the condition. They filed the case, and this after filing of this petition, authority has granted allotted pension to their accounts, my lord. On condition that you make 50% amount. When they also make commitment before this honorable court, the loss of list order is there.
Hmm.
They will ready to pay 50%.
Why the amount has not been paid?
Now they file a petition, my lord, misleading the court.
Actually, Lordship, Mr. A.R. Bhuya will appear for this matter.
Who?
He is on leg, A.R. Bhuya. He is on leg in the
Okay,
other court.
let him
Maybe,
come.
my lord, the original is not. we have-
Okay, let him come.
Will be fair, my lord.
Pardon?
We may be fair, my lord.
I come from motion, item number 1, parliamentary.
Yes, Lordship, here though I have received the instruction, but I have found some small, like, some mistakes have been done, so I have get the director to make the correction and I will get an instruction Lordship during the course of the day. So as this matter is a part of Mr. Lordship, immediately on the next reopening date, Lordship can be fixed. So that we will also have to find an affidavit, Lordship, because the long time I have received, Lordship. Only I have seen, Lordship, that some mistakes are there regarding, so I have requested them to correct that instruction, Lordship, that I will receive during the course of the day.
So matter can be taken today, tomorrow, my lord. If he is
But there is
receiving.
no other thing, we have a lot of things to, we'll find affidavit, Lordship, in this case. Lot of things will be taken before it. It is not what is projected. in
No,
the-
what is the matter
Regarding provincialization, Lordships. Right.
regarding?
Provincialization of the subject.
Yes. Okay, let it be after reopening.
Yes, yes, Lordship, nothing was immediate on the next year.
But there is a problem after 30 days, so that may can be specially observed.
Okay.
It becomes
Heard,
a
sir.
non-part heard.
Mahmood, Learned Counsel for the
Oh, let's give
petition.
it part of Lordship.
And Mr. SMT Sisti, Learned Counsel for the Elementary Education Department. Mr. Sisti Samit said he has received instruction, but he will file the affidavit in opposition, bringing on record the said instruction that he has received from the respondent authorities. And he applies for listing the matter immediately after reopening of the vacation. Where allowed, Resist shall list the matter on.
Apply the part.
As part heard.
Okay.
I think 31 for return.
May I please, your lordship, my lord, I have been recently engaged as well as my lord, instruction have been received on written from the petitioner, my lord, all reliefs he had been granted.
Hmm.
So, my lord, we are not pressing further.
They Ahmed will appear.
My
He
lord,
has objection in
objection
recording
in-
permission to withdraw this
no,
petition.
no, my lord, this is my writ petition, my lord, I want to withdraw, my lord.
Maybe, but he submits that some order of this court has not been complied with.
No, no, my lord, there is no any such order, my lord, only an undertaking had been given that 50% would be paid to her. Now, my lord, if we do not pay, recourse of law is available to them, my lord, they can come up with a separate writ petition, my lord, this is my.
Let Mr. Ahmed come. Cover it, next slide.
Item number 2.
May I please, your lordship? My lord, this is contempt petition, my lord. Order is relevant point, page number 11.
Hmm.
Serial number 8, my lord. And next page, my lord,
The
I have-
notice was issued or not? Not issued. It's of 2024 matter. Let notice go at this issue.
my lord,
Heard, Mr.
FL Oscar, my lord.
FL Oscar, Learned Counsel for the petitioner. Being aggrieved with willful and deliberate violation of the judgment and order dated 4/8/2023 passed by this court in WPC number 4392 of 2023. This application under Section 12 of the Contempt of Court Act 1971, read with Article 115 of the Constitution of India, is prepared by the petitioner, namely Salim Hassan Kazi. Peruse the petition and the documents placed on record, and also peruse the order dated 4/8/2023, passed by this court in WPC number 4392 of 2023. Let notice be issued to the respondent, returnable in 4 weeks. Step be taken by speed post and also by usual process within a week from today. This is a matter after 4 weeks. But whether this person is Akashdeep is the is the principal secretary of BTR,
My lord,
still holding the post.
still working, my lord, so far my
Okay,
instruction.
Numbers 3 and 4.
Obligement.
Ration papier.
Yes.
The one communication from the director, that is with regard to the query that was put in the last hearing, that why the date has, the joint committee has mentioned that there was no date in the district scrutiny committee. Though the district scrutiny, as per the annexers annexed in the repetition, there is a date. So one of the instruction that is sent from the director is with regard to that query. The other communication from the secretary was with regard to the query that was raised. Under what authority this joint committee has been constituted.
Hmm.
Now, look, in WPC 6780, here a challenge has been made with regard to the recommendation of the joint committee. Now, in the WPC number 6997/2025, here one of the challenge has been made to the constitution of the joint committee. And therefore, my lordship will give us time to bring our stand on affidavit. Finally, your lordship has to decide the legality of the constitution of the joint committee. Therefore, we would like to file our affidavit. Well, I've given a note, the note under the circumstances why the joint committee has been formed. And this joint committee has been formed at the instruction of the finance department. So that when the provincialization proposals are sent, there should not be any error in the proposal. And for re-verification, after only with respect of DICE data and the other criteria of the provincialization, that is done by the joint committee, which consists of both education and the finance department offices.
No, but the question is whether the statute or any rules has provided the same.
Well, the recommendation of the joint committee cannot supersede the decision of the committee, statutory committee.
No, the problem is that the joint committee is sitting as the appellate authority of the High Court. Where they assume the power.
Absolutely not. Nobody is, even
Then-
statutory committee
then-
doesn't have the powers to do that. Even the statutory committee, in my respectful submission.
No,
doesn't
you
have that
tell
power.
me, while we used to direct the government, we used to direct the director or either the secretary. But
Even case, well, if that.
no, you
so-
say Thereafter, the file went to the finance department. And finance department is another authority to reject the same. So government should speak in one voice, not in multiple voice.
Nobody can dispute that, my lord. In fact, in a given case, if the decision is of such nature, my lord, that will, of course, will not withstand legal scrutiny.
Okay, you furnish a copy of the same to
I'll
Mr. Mandal.
give it. So in fact, my lord, I'll bring it by way of an affidavit.
Okay, you file your affidavit.
Affidavit. On the evening, my lord.
Lord,
Fix.
may I submit one thing? Lord?
Mm.
Now, from my friend's Lord, argument, assuming that the joint committee has the power, assuming, my lord, but in our case, my lord, absolutely error apparent on the face of record.
No,
Lord says there is
Mr.
no date.
Mandal, you see, the main page of the recommendation, there is no signature.
Yes. That is, my lord, downloaded copy we have obtained from, my lord, RTI. We are having the, my lord, signatures copy, my lord.
No, this copy.
Yes. The recommendation, my lord.
Yes.
The recommendation signature is there, my lord. That is the first page. The operative paid lordship, kindly see page 80, I think. Sorry, my lord.
No,
Page 58, lordship, kindly
Mr.
see.
Mandal,
My lord.
you obtain a copy from him, you go through it, and he come prepared on next date.
Yes.
In the meantime, he will file his affidavit, bringing on record the facts under which the joint committee has been constituted.
Signature is there, lordship, kindly see page
The
56.
signature is there in page number 61 and 62. There is no date.
That is the, my lord, annexer. Yes, but the, my lord, very,
One,
my lord, page 60, lordship will find. Again, my lord, page 59, lordship will find there is a date and signature. Page 59, 16/2/2019. Then lordship will find, my lord, page 60, there is a signature, chairman.
But
district level.
where is the date?
Page 59, my lord.
60,
59,
60.
60. Yes, 60, my lord, below, my lord, there is a signature.
Where is the date?
Yes, page 60, there is no date. In the first page,
Page
date is
61.
given.
Page 61.
Page 61,
Where is
yes,
the date?
it is annexer. There is
Yes.
no date. There is no date.
So therefore, they want to verify it.
Yes, my lord. That is, of course, not our fault, my lord. It is the.
That is not your fault, but there's a manipulation cannot be ruled out.
Yes, that can be.
Cannot be ruled out.
That is why, my lord, re-verified
Yes.
and authenticated also subsequently by the department.
Part Mr. Mandal, learned counsel for the petition, or Mr. B. Kosik, learned standing counsel for the respondent in elementary education department. Person to direction issued by this court by order dated 8/12/2025. Mr. Kosik has produced the instruction he has received from the respondent authorities. And he also submits that he may be granted some time to bring on record the said instruction by way of an affidavit in opposition. Where allowed, recess shall list the matter on
19th January.
19 January.
Can it be on earlier, my lord? We are suffering a lot, my lord.
9th of January. In the meantime,
Develop.
Mr. Kosik, learned standing counsel, shall furnish of a copy of the instruction he has received to Mr. Mandal during the course of the day. Mr. Mandal and Mr. R. Islam.
Lordship, my interim order may kindly be passed,
Okay.
Lordship. Lordship, what happened, Lordship? In my case, Lordship, regarding enrollment, Lordship, as per law, my enrollment is required 10, Lordship. I have 11, Lordship, which has been reported by the Controller of Examination, Assam Higher Secondary Education Council. Lordship, may kindly peruse page 41 for a moment. It is already indicated that my enrollment is.
Mr. Islam, already you have pointed that
Lordship, I have, Lordship. Lordship, page
during
41.
on 8/12/2025.
Lordship. Page 41, Lordship, my enrollment is 11, Lordship. Now, as per law, it is required 10, Lordship. Now the director has obtained enrollment from Seva, Lordship, that with page 46 may kindly be perused. That created problem, Lordship. Seva is not a appropriate authority, Lordship. Page 46, last column, Lord. I am serial number 2, Lordship. Number of candidates received through Chairman Seva is 06. Now, for which my name has been dropped, Lordship. And subsequently, Lordship, my name has already been recommended by the state level committee, district committee as well as state level committee. Now, finally, Lordship, this joint committee came in.
Okay, let him file affidavit.
Lordship, till then, Lordship, it is stated that they will examine the reason. It will take again some years, Lordship.
No, let them file affidavit.
Lordship, only thing is
On
page
fifth.
31, Lordship.
I'll file on 5th. Lordship has fixed on 9. I'll file on 5th on the reapproval.
Okay. 9th, interim order pass earlier shall continue.
All right.
Item 32, promotion.
May I please, your lordship, this matter relates to suspension. My lord, the petition is doctor. That suspension order is page 30, in page 35. Well, already 3 months expired, but no charge sheet and no, my lord, a review order has been passed. And
Health and family welfare. Who is for health department?
department,
Whatever. Can you inform him?
Yes, I'll inform you.
Wait for something.
Item 33.
May it please your lordship. Lordship, this is a matter pertaining to pay disparity. Basically, the petitioners herein are the employees, non-teaching staff of the KK Hendick or State Open University. The crux of the issue is such that, lordship, basically the pay scale and the grade pay of the employees concerned is in disparity in comparison to the similarly situated employees of the other universities. So what had basically happened, lordship, initially they were appointed on fixed pay. However, later on they were regularized. And in the year 2010, the Honorable Governor of Assam had constituted a pay committee, common pay committee, wherein the whole purpose was to bring in uniformity amongst the non-teaching staff of the universities of their pay scale and the grade pay. Now, upon perusal of the report, which was submitted in the year 2010 itself, the university authorities noticed that there is a huge disparity amongst the employees. For your lordship's perusal, we have appended the chart, lordship, at page 13 of the petition. Lordship will kindly peruse it. Lordship, thereafter, after noticing such disparity, the authority approached the concerned authority, who thereafter, in the year 2016, now, during the interregnum, in the year 2017, the Common Pay Committee of 2017 was published, and in there again, it was the effective date was given 01/04/2016. Now, again, upon the perusal of the CPC 2017, it was observed that there was disparity in the same manner which had happened in the 2010 CPC. Upon such observation, the registrar of the KK Hendick University submitted a letter to the registrar of Guwahati University, who was also the registrar of the review committee of the committee which was constituted for CPC 2017 lordship. Thereafter, this anomaly was placed before the anomaly committee, which was forwarded to the government of Assam. Thereafter, lordship, the impugned communication dated 31/8/2022 was published, which your lordship will find at page 84 of the petition, lordship. Lordships has it?
Yes.
So Lordship, basically in this impugned communication, the pay parity was granted. However, it was granted prospectively, that is to the immediate date instead of giving it from 0101 instead of the year 2009, Lordship. Thereafter, a resolution dated by the Finance Committee in the year 10-10-2022 was constituted. And in that resolution, the Finance Committee had resolved that they will give effect from the inception of the university instead of giving effect of the same from the year 2016, and the arrear payment shall be the liability from the university fund. Upon such development, Lordship, the finance officer of the university issued an order dated 9/12/2022 in which he had passed an order whereby he had said that basically the effect will take place from 01/04/2016 instead of 01/0/2009. Lordship will find that at page 87 of the petition, Lordship.
Yes.
Thereafter, Lordship, another meeting was held on 19/9/2025. It was the 81st meeting of the Board of Members, who again held that no, it will not be given from the year 2016. Instead, it would be given from the year 2009 itself. But in the interregnum, Lordship, after that, on 11/6/2025, the 82nd meeting of the Board of Members was constituted, in which they had again resolved, superseding the previous orders, that they would now constitute a subcommittee consisting of 3 members, and the 3 members would constitute of Lordship, the finance officer of the university, the special secretary finance department, and the additional secretary and SPIO of the higher education department, who were to take the which decision was already taken in the meeting held on 19/2/2025. So again, constituting a subcommittee for the same agenda is incongruous, Your Lordship. Now, finally, after the same subcommittee, this 3-member committee held their meeting, Lordship, on 30/7/2025 and 7/8/2025. The minutes of the order dated, Lordship, you will find it at page 130 of the petition. So, Lordship, basically in the minutes of this meeting dated, the committee held that the employees has no right to the pay parity, and they shall not be given with effect to 2009, and without applying any mind, on only 3 grounds: that they were on fixed pay, or that they were on fixed pay at the time of the inception, and they were fixed erroneously at the time of the inception, and the error. So disparity in pay scale crept into the advertisement also. So this is the case of this is the crux of the issue of our petition, Lordship. At this stage, Lordship, we pray for notice.
You file your affidavit. Okay. Heard, Miss?
B. Saikia, Lordship, on behalf
Learned
of
counsel for the
Kedar.
petitioner and Mr. Learned counsel for the respondents. Respondent number 1, 2, and 3. And who is for Commissioner and Secretary? Higher Education Department. So we have not received copy.
Yeah,
Actually, I'll finish during the course of the day. It has to be.
Mr. Tobiller, Learned Standing Council for the Higher Education Department, being respondent number 4, 5, and 6. 4 and 5. 4, 5, 6. 4, 5, 6. The petitioner herein are the non-teaching staff of KK Hendrik State Open University. They are aggrieved for disparity of their pay with their counterpart in the Goethe University. And also they are aggrieved for giving prospective effect So by which order the prospective effect is given? Page number 87.
Lordship, it is, the impugn order is 31/8/2022, Lordship.
Page number
Lordship. Page number 84, Lordship.
4,
Annexure 15.
84. And though the respondent in Higher Education Department has admitted that there is discrepancy between the various universities and the grade pay of non-teaching staff of KKHSOU, the department has approved grade pay in respect of the non-teaching post of KK Hendrik State Open University, but the same is given effect from 1/8/2022. Whereas the petition and the documents enclosed therewith. Let notice be issued to the respondents returnable in 4 weeks. However, no formal notice is required to be issued since all the respondents are represented by their respective standing council. But extra requisite copy of the petition will be furnished to them during the course of the day. Rest shall also reflect the name of the Learned Standing Council for the Higher Education Department, being respondent number 4, 5, and 6. List the matter after 4 weeks. In the meantime, the state respondents may file their affidavit in the registry. List after 4 weeks.
Lordship, kindly fix a date, Lordship.
Only notice will go
Sorry, sir.
after 4 weeks.
4 weeks.
34.
Deeply obliged, Lordship.
You have received.
We will do.
They will
Lordship,
furnish
we will give it. As you can.
during the course of the day. They will furnish. Yes, already directed.
Deeply obliged, Lordship.
May I please, your lordship, this is,
The petitioner before Lordship is a constable with the CRPF, my lord. I'm assailing a dismissal order, my lord, through DP, my lord. 3 orders are being assailed. Original order is of 28/7/22. Lordship will find it annexure A. Then it was assailed before the appellate authority. It was rejected 21/11/22. Then Lordship will annexure B. Again, my lord, before the revision authority, another revision was filed. That was also rejected, my lord. The purported allegation was that I contracted second marriage during the subsistence of my first marriage. Page number
But
19, my
are
lords.
you entitled to?
My lords.
Are you entitled to?
No, my lords. It has been by judicial intervention, my lords, that so-called purported second marriage has been held to be illegal, void, my lords. That lordship will find there was a matrimonial suit filed by the wife of the petitioner at page 7, annexure D. Page 73. That very purported marriage has held, that very marriage certificate has held to be, my lords, void.
Maybe, but you have already contacted second marriage.
No marriage. No, my lord. I had some live-in relation, my lord. There was no marriage. And even, my lord, the authority, while passing the orders of dismissing me, my lord, the complainant there too, my lord, the purported second wife was called, but she didn't participate, my lord. There was no second marriage, my lord. My lord, at least at this stage, I just pray for a notice, my lord.
Heard Mr. D. Gogoi, learned counsel for the petitioner, Miss
M. Verma, on behalf of SK Medicines.
M. Barman, learned counsel appearing on behalf of Mr. S.K. Naidu, learned CGC. In this petition under Article 226 of the Constitution of India, the petitioner has challenged the order dated 22nd of July 2020, passed by the Commandant 222 Battalion CRPF, whereby the petitioner was removed from the service. And he also challenged the order dated 21st of November 2022, passed by the Deputy Inspector General of Police, Khotkote, whereby the appeal preferred by the petitioner was rejected. No, whereby the appeal dated 7/9/2022 preferred by the petitioner was rejected. By order dated 28. No. By which the order of removal was affirmed. Order of removal dated 20. Mr. Gogoi.
My lords.
You see, page number 16 in the pair portion.
60, my lords. 60.
16. The impugned order is dated 22nd of July 2020.
My lord, I'm challenging 3 orders.
No, that's all right.
My lord.
A removal order is updated.
Removal order, my lord. Original order is of 22/7, 2020. My lord, then impugned order. My lord, is 2022, my lords. That it is.
No. You see, the removal of service dated, order of removal of service dated 28/7/2022.
2022, my lord. It's 2022. It's.
No, that's all right. But in the first order, what is the date?
My lord, it's 6 April. 6 April 2023. The revision order.
In the second pair.
Second order, my lords. My lord is indicating the appeal order.
Yes.
Appeal order.
There you have mentioned the order of removal of service dated 28/7/2022. Is it correct?
My lords, it is a appellate order of 21 November. It has upholded the 28/7, my lords. Some
28/7.
28/7.
No, this, your removal order is of dated 22nd of July 2020.
2022,
Your first pair.
my lords. My lord, it will be 22/7, my lords. 22/7. Erroneously, my lord, it is
22/7.
28.
22/7/2022 or 2020?
2022, my lords.
And in the second pair, you see, order of removal of service dated 28/7/2020.
No, my lord, some this is corrected, my lord, clerical mistake. It's 2020, 22/7/2022, my lords.
প্ৰথমটো লিখিবা 22/7/2022. Second to
My lord, you'll find that at page 29. Because of Hindi, my lords, we have some 20, page 29, lords, you will find 28 July 2022. Yes, this is not proper. Page 19, my lords, at the heading, my lords, is
in order
Dinank
dated
28.
21/11/2022, passed by the Deputy Inspector General of Police, Khatpati, rejecting the appeal dated 7/9/2022, filed by the petitioner, and affirm the order of removal of service dated 22nd of July 2022, passed by the Commandant 222 Battalion CRPF, and the order dated 6/4/2023, passed by the Inspector General of Police CRPF, Shillong, whereby review petition referred by the petitioner against the order dated 21/11/2022, passed by the Deputy Inspector General of Police Khatpati, and also to issue direction to the respondent authorities to reinstate the petitioner with all consequential benefit. Peruse the petition and the documents placed on the record, and also peruse the impugned orders dated 22nd of July 2022, 21/11/2022, and 4/6/2023. Let notice be issued to the respondents returnable in 4 weeks. However, no formal notice is required to be issued since all the respondents are represented by their English counsel. However, it's a requisite copy of the petition be furnished to the learned standing on the learned counsel for the respondent during the course of the day. List the matter after 4 weeks. In the meantime, the respondent authorities shall file their affidavit. List
Full
after 4 weeks. Okay. Itu eta line logai diba. Also appears that from errors of that crafting in the fair portion of the petition, the learned counsel for the petitioner is directed to file appropriate application for amendment of the, no, for correction of the aforesaid dates.
May I please? May I please, Your Lordship?
Yes.
The petitioner herein is the daughter of late Abdul Malik, retired and deceased teacher of classical teacher of Sibar High School. The father of the petitioner died on 28/02/2011. Thereafter, the mother of the petitioner got the benefits of family pension. But unfortunately, she also died on 4/11/2020. Annexure 1 is her death certificate, page 11, Your Lordship. Thereafter, the petitioner being a minor, her brother preferred an guardianship application, and which was disposed of by order dated 07/02/2022 by the District Judge Kachar, page number 13A, Your Lordship, Annexure 2 is the order. And annex, page 15, annexure 3 is the certificate, guardianship certificate.
So this family pension has been, compassionate family pension has been granted to you.
Yes, your lordship,
but
annexure
they
5,
have,
but the
withheld
competition
41
period, we are telling the competition period, means it ought have been calculated from the date of the death of the mother. But it was computed only from 30th March 2024, that is annexure 5, page 18. Page number 18, your lordship. May I read, your lordship? Page number. I am to forward here with the PPO number so and so in favor of legal guardian Muhammad Salahur Rahman on behalf of Aisha Bibi, daughter of late Abdul Malik, teacher, and 100% share of unmarried daughter pension at the rate of rupees 13400, 13,400 only with
Okay.
effect from.
You have been denied compassionate family pension for 41 months.
Yes,
40, that is your grievance.
yes, your lordship.
Okay.
We have made a representation also, which is
When?
page number
Page number?
19, your lordship,
19.
annexure 6. For review of the pension. Sorry.
Yes, so who are appearing for the respondents?
I'm appearing to the assistant. He'll be appearing for pension. Direct the director of pension to dispose this representation within a period of 1 month.
Yes.
Yes,
Heard Mr.
M.R. Sodil.
M.R. Sodial, learned counsel for the petitioner, and Mr. D. Kosik, learned standing counsel for the respondent in. Oh, yeah, for respondent number 2,
I'm appearing for 1,
respondent number
4,
1,
5.
1, 4, and 5.
1, 4, and 5.
1, 4, and 5. Ms. Esco for the respondent number 3. And finance department. Inform Mr. Soleha. Soleha. For finance department. The petitioner hearing has tried for issuing direction to the respondent authorities to make payment of family pension to the petitioner with effect from 4/11/2020. The learned counsel for the petitioner submits that the father of the petitioner was serving
Is a classical teacher,
as classical teacher of
Shribar High School.
Srivor High School, Kasar, and he suffered demise on 28 to 2011 after his retirement. Thereafter, the family compassionate family pension was received by the mother of the petitioner.
Yes, your lordship.
Petitioner. and her mother also suffered demise on which date?
4/11/2020.
4/11/2020. Thereafter, the petitioner, through her
Legal guardian.
legal guardian, applied for compassionate family pension. Then the authority has granted the same. With effect from
30 March 24 up to 29/10/25.
31
30 March.
3/3/2024 to 29/10/2024. But she has not been granted family pension with effect from the date, that is 4/11/2020, on which her mother suffered demise. And being aggrieved, the petitioner approached this court by filing the present petition. The learned counsel for the petitioner submits that the petitioner has filed one representation to the director of pension on
11 November 25.
where is the date?
Lower part, handwritten.
11 November 2025. But the same has yet to be
Considered.
has not yet been disposed of by the respondent authority. Mr. Kaushik, learned counsel for the respondent number so and so, however, submits that this writ petition may be disposed of by directing the respondent number 3, the director of pension, to dispose of the representation filed by the petitioner in a time-bound manner. The learned counsel for the petitioner submits that he has no objection. Accordingly, taking note of the submission of learned counsel for both the parties, it is provided that the respondent number 3 shall dispose of the representation dated 15th of November 2025, filed by the petitioner within a period of 4 weeks. By 4 weeks from the date of receipt of certified copy of this order by a speaking order. The petitioner shall obtain a certified copy of this order and place the same before the respondent number 3 within the period of 1 week from today.
Along with this representation.
Along with the representation and copy of the petition and the documents. and
Deeply obliged.
Maybe. Well, here in this case, we have put to challenge the order passed by the Educational Tribunal, my lord. Earlier, this honorable court directed the petitioner to approach the, my lord, tribunal by order dated 27/4/2021, Annexure 8 WBC, page number 52. After that, the petitioner has approached this, my lord, tribunal.
Why the impugn order is nonetheless in the eye of law?
My lord, one thing is that, my lord, that tribunal, my lord, in the last part, my lord, I take your lordship to page number 111. Paragraph 23, my lord. Thus, it is clear that the petitioner had received due remuneration of her service from the government during the course of her service to the school. The 2 posts of assistant teachers has been provincialized in the said school, and the persons whose posts were provincialized were senior to the petitioner, and that she was serving as assistant teacher arts against 3rd post. Until date, the 3rd post of assistant teacher is not approved by the government. And as such, I am of the considered opinion that the petitioner is not entitled for a decree of provincialization of her service post at the said school till date, and that the prerogative to the consider the provincialization of the said post in the hands of the government, Director of Secondary Education Assam. As such, issue number 2 is decided in negative and against the petitioner.
In view of the above discussions, the petitioner is not entitled for decree of the or decree for provincialization of her services, my lord. What happened, my lord? The learned trial court, my lord, held that the petitioner is not entitled because the third post has not been approved. But the appointment of the petitioner, my lord, it is approved by the IS, my lord, Annexure 5, page number 43, and initially in the post of Hindi teacher.
Let notice go at this instance.
Yes, sir.
Let the record come.
Yes.
Heard Mr. Pulkesto, learned counsel for the petitioner, Mr. B. Kosik, learned standing counsel for the respondent. Elementary Education Department,
Secondary.
Secondary Education Department. The petitioner hearing has challenged the order dated 8/9/2025 Paspeta Learned Educational Tribunal, Education Tribunal Moregaon, in Tribunal Case Number 06 of 2021, whereby the prayer of the petitioner for provincialization of service has been rejected. Whereas the petition and the documents placed on record, and also whereas the impugn order dated 8/9/2025. Let notice be let notice be issued to the respondents, returnable in 4 weeks. No, admit. Appeal no. Let notice be issued to the respondents, returnable in 4 weeks. However, no formal notice is required to be issued since all the respondents are represented by Mr. Kosik, learned standing counsel. But extra requisite copy of the petition will furnished to him during the course of the day. SSL call for the record of Tribunal Case Number 06 of 2021 from the Learned Education Tribunal, Moregaon. List the matter after 4 weeks.
It is the first week of February, my lord.
4 weeks after. Let's see service.
37.
May I please, Your Lord?
Yes.
In this case, my lord, the petitioners, my lord, has been discriminated, my lord. My lord, by the respondent.
One of the petitioners was a party to the earlier suit.
Acha.
My lord, the subject matter and the issue involved in this case are, my lord, different. May I submit, my lord? May I make my submission first, my lord? Then my learned friend will, of course, my lord, will respond on that, my lord.
No, if the issue has already been decided.
No, my lord, with all respect, my lord, here is the issue, my lord, which has not been decided by this honorable court. My lord, within a few minutes, I'll demonstrate, my lord, as to how the petitioners has been subjected to, my lord, hostile discrimination. My lord, what has happened? The petitioners before your lordships, my lord, some of them are PhD degree holders, but some of, my lord, are pursuing, and they are, my lord, holding in charge of the different, my lord, colleges in different places, my lord. Now, by, my lord, from 1 to 8, your lordship will find, my lord, the orders by which, my lord, time to time the petitioners were allowed to hold, my lord, charge, principal in charge from time to time, my lord. It was extended from time to time. And till today, my lord, they are working, my lord, for last 10 to 15 years in the said colleges, my lord. They are founder teacher, my lord, of the colleges, and they have gained, my lord, in the meantime, a vast, my lord, administrative experience, my lord, to run the institution. My lord, your lordship kindly see, my lord, at page 9, annexure 80, my lord, annexure 9, page 80. By that notification, my lord, the government has, my lord, issued an order by creating 41 post of, my lord, post of principal, my lord, and thereby, my lord, initiated a process for direct recruitment to the post of, my lord, principal in charge. Now, my lord, there are certain guidelines as prescribed by the University Grant Commission, my lord.
So some of the petitioners have not acquired the PhD degree.
Some of them acquired, my lord. Some of
them
them are having PhD degree,
Hmm.
and some of, my lord, are pursuing the PhD degree.
And they are holding the post of in-charge principal.
In-charge principal in the college.
And your pair is to allow them to remain as such.
My lord, our pair is to remain as such, my lord, and moreover, my lord,
Hmm.
my lord, there is a provision in the Act of 2017,
Hmm.
Section 7 of the Act, which says, my lord, those who have not acquired the requisite qualification, my lord,
Hmm.
5 years time span may be allowed for acquiring, my lord, requisite qualification.
Hmm.
That is there in the law, my lord. Section 7 of the Act of 2000. I have quoted that, my lord, in my writ petition. Your lordship will find. My lord, page 17, my lord. Page 17. Sorry, page 21 at paragraph, my lord, 17. I have quoted the, my lord, relevant provisions of law. So law is there, my lord, that we may be allowed some time, my lord, to acquire the requisite qualification. Now, my lord, my case is something different. My lord, here your lordship will find, my lord, annexure 13, page 85. My lord, similarly situated person, my lord, has been directly, my lord, appointed as principal. He was also, my lord, holding charge of, my lord, principal. Then by order dated, my lord, page 85, your lordship will find, my lord. Annexure 13, page 85, my lord. Similarly situated person. He was also, my lord, holding in charge. And, my lord, he has been directly promoted, my lord, to the post of, my lord, principal in charge. My lord, principal. May I read this order, my lord?
No, not necessary.
My lord, this gentleman, my lord, Dr. Arun Bora.
So, Mr.
Then,
Say-
my lord, your lordship will find, my lord, page annexure 14, page
No,
89.
Mr. Sen, you say in order to hold the post of in-charge principal, you must have the requisite qualification for being appointed as regular principal.
But by the annexure
you-
85, my lord,
If you do not have the NET, CLET or the PhD degree or MPhil degree, how can you be allowed to remain in charge?
my lord, because, my lord, section 7 of the Act
Hmm.
says, my lord, those who are not having, they may be given an opportunity because they are holding charge, my lord. They have acquired experience in the post, my lord. Therefore, Act says, my
No,
lord,
what the regulation or the rule says?
rule says, my lord,
Then is
so-
is it the position that till acquiring a PhD degree or NET SLET by you, the respondent authority will not appoint the regular principal?
no, my lord, that is not my case. My case is that, my lord, similarly situated person. By annexure 13
No,
and
you see,
annexure 15, my lord,
you see this person.
this
who is
person was
appointed as
only,
regular
only
principal,
having,
he
only
has-
having PhD degree, no other requisite qualification, my lord.
Hmm.
We are also having PhD degree.
Hmm.
Other requisite qualifications are
No,
not available.
as already submitted by you, some of them are not acquired the PhD degree.
My lord.
Then
Some-
how they are similarly situated with this person?
Well, lord, so far as the persons who have acquired the PhD degree, my lord, PhD degree is also there, my lord. Some of them, those who are acquired PhD degree, my lord, having PhD degree, they are entitled, my lord, in terms of the, my lord, annexure 13, page 85. White annexure 13, page 85, my lord, they have been on the day of provincialization, my lord, of the college, they were upgraded to the post of, my lord, principal from the in charge principal, my lord. So, my lord, is not it discriminatory, my lord? Here also, my lord, there is no requisite qualification, my lord. Your lordship, see, my lord.
Yes, Mr. Das, what
My
is
lord,
the
it pay-
qualification
Num-
for being appointed as a regular principal of a college?
Assistant professor. Associate professor with PhD with 15 years administrative experience.
But annexure 13 and 15, my lord,
Top of
no,
everything else.
no, my lord.
This case has been filed so jumbled up manner. All the petitioners have different cause of action. Chapter 5 rule, rule 1 of Guwahati High Court rule says you cannot jumble up all cause of actions by making one petition. It should have been a separate petition for all the petitioners. Some of them are having, they himself said, some of them are having qualifications, some of them not. Some have joined 2000 so and so, 1999, some of them in 2000.
But-
These are all separate cause of action.
No, my lord, there is similarly situated. All persons are holding.
This is
hold-
the article.
High Court rules. My lord, no, my lord, no. With all respect, my lord, they all are holding in charge principal, my lord. That is their criteria, my lord. They are holding in charge principal. And the persons, my lord, who is PhD holder, my lord, they have been directly, my lord, promoted to the post of principal, my lord. That is my case. But in our case, my lord, they are saying that rules has to be followed, my lord. Is not it discriminatory, my lord? Your lordship kindly, let me complete, my friend. Just a minute, let me complete. My lord, your lordship kindly see, my lord. My lord, page 89, annexure 14. This is also important, my lord. One hand, my lord, they have initiated process for direct recruitment through, my lord, advertisement and all, selection and appointment, my lord. And on the other hand, my lord, by annexure 14, page 89, your lordship kindly see, my lord. Some of the principals, my lord, provincialized colleges appear for verification, as your lordship got it, my lord. With reference to the government letter on the subject cited above, I am directed to request you to inform the concerned tutor principal. My lord, tutor principal, my lord, in charge principal is equivalent to in charge principal. Yes. Librarian representatives to appear document verification on master degree so and so, so and so, so and so. They are requested to attend positively and to bring all relevant documents in original on verification in support of their claim for upgradation. This is very important, my lord. For upgradation from the post of tutor principal, tutor assistant professor, my lord, similarly situated person, petitioners before your lordship, to the post of principal. My lord, one hand, they have initiated process for direct recruitment according to them, my lord, as per rules. On the other hand, my lord, by annexure 14, page 89, my lord, they are, my lord,
No,
issued
Mr.
later.
Sen, you see, the person, the petitioners who have PhD qualification and those who don't possess the PhD qualification, the cause of actions are different. Why don't you file a separate petition?
Oh, my lord, because all the persons, my lord, before your lordship are principal in charge. Holding, my lord, post of principal in charge.
Hmm.
Now, my lord, their grievance is that some of the similarly situated
No, no,
persons.
some of them do not possess the qualification also for
They
being
are
appointed
pursuing,
as
my lord, in
principal.
terms
Then
of rule, they are pursuing in terms of rule, my lord, section 7 of the Act, my lord,
Hmm.
2017. Because Act says, my lord, some time frame timeline may be given to them to acquire qualification because, my lord, they have gained, my lord, administrative experiences in the field, my lord. And therefore, my lord, and this annexure 15, my lord, your lordship kindly see, my lord. Annexure 16 is the last, my lord, annexure, page 94. Here also your lordship will find, my lord, one gentleman, Dr. Rupam Kumar Bora. He has been also directly appointed to the post of, my lord, principal, from the post of, my lord, in charge principal to directly, my lord,
no,
with effect
here,
1/1/2023.
Mr. Sen, you see, come to Annexure 1.
Annexure 1.
Yes.
Yes, my lord.
Here, the serial number 4, candidate at serial number 4. His professional qualification is blank.
Serial
And
number
number 5, he is pursuing PhD, and number 6, pursuing PhD. So whether their cause of action with the others are
My
similar?
lord, your lordship kindly say most of them are holding PhD, my lord. Kindly consider, my lord. Of course, my lord, one or two, my lord, they are pursuing, my lord, the PhD. I have annexed the, my lord, PhD certificate, my lord, and my lord, the persons who are pursuing their, my lord, PhD in different institutions, my lord. But fact remains, my lord, that they are holding in charge.
Okay,
In charge,
let notice go at this is this.
my lord.
Heard Mr. Sen, Learned Counsel for the petition. Mr. Das, Learned Standing Counsel for the respondent in Higher Education Department. Mr. Somua for respondent number. Mr. Somua. Mr. Somua, you are for respondent number. Respondent number 3. And Mr. Tobilder for? Okay.
Yes, that's good.
In this petition under Article 226 of the Constitution of India, the petitioner has right for issuing direction to the respondent authorities to allow them to participate in the selection process for being appointed to the post of regular principal in their respective college who are possessing requisite qualification for appointment to the said post. And also direct the authorities to allow the petitioners, those who do not possess the requisite qualification, to pursue them to acquire requisite qualification within time frame for selection and appointment of the petitioner to the post of regular principal in the colleges of the petitioners, till the petitioners until the petitioners may be allowed to continue serve as the principal in charge in their respective college. Where is the petition and the documents passed on record? Let notice be issued to the respondents, returnable in 4 weeks. Step be taken by registered. However, no formal notice is required to be issued. But governing bodies are not represented by anybody. Mr. Das for respondent number 1 and 2. 1 and 2. And Mr. Somo for 3. Notice to the rest of the respondent be issued by speed post and also by usual process within a week from today. List after 4 weeks.
my lord, in the meantime,
That may be observed, my lord.
in the,
Availability of the.
My lord.
The reputation to be kept open.
Yes, my lord, I have, my lord, my lord, all right, my lord, what my learned friend is saying, my lord, maintainability, let it be open, let it be kept open, I have no objection, my lord. Only thing, my lord, may I pray, my lord, till returnable date, my lord. My lord,
They are not associate professor, they do
they-
not qualify.
they-
But this petition is liable to be dismissed, my lord. There is
No,
a
my lord,
matter of fact, one
my
of
lord,
the one of the petitioner
my
has
lord,
already filed a case and that case is just that claim, similar claim,
Till-
my lord, same claim has been dismissed.
till
And there
returnable
is-
day, my lord,
No,
the,
this
the,
petition regarding filing of the previous
my
case,
lord,
my lord. And some other petitioners has also approached this honorable court. They have taken liberty
My
to
lord,
file
this-
fresh case, my lord.
petitioners colleges, my lord, petitioners colleges may kindly be, my lord, kept in abeyance.
Sorry, no intermediate.
My lord, these 7 colleges, my lord, out of 41.
So, maintainability of the petition is kept open.
In view of the judgment rendered in that case. Separate cause of action and.
In view of the judgment referred by Mr. Somua Learned, standing counsel for the respondent number 3, in WPC number 3506 of 2024, and also in view of rule
Chapter 5A, rule 1 of High Court.
Sector 5A, Rule 1 of Guwahati High Court. List accordingly.
My lord, in some of the colleges, my lord, interview has been taken place, my lord, only appointment is left, my lord. That's why, my lord, may I pray, my lord.
No.
The outcome of this writ petition,
sir.
my lord, subject matter of the, my lord, the process initiated by the government.
No. Next item.
I am deeply obliged. I am obliged, my lord.
May I please, your lordship? My lord, I have been engaged today. My wakalatnama had been filed. Along with that, my lord, I have received a letter in written, my lord, from the petitioner with a request to pray before my lordship to withdraw the petition, my lord. So, my lord, this is my petition, my lord. I may be allowed to withdraw, my lord. Because, my lord, the grievance which has been raised in this petition, my lord, regarding the grant of family pension and other benefits, my lord, which has already been granted by the government. That is the issue, my lord.
The Lordship kindly say order that 17/11/2025. On that day, the filing layer, the original layer, make a statement on the status. Then, my lord, that advocate has been sent, new set of lawyer has been engaged again. Matter was listed on 9, 9/12. 9/12, the honorable reasonable court, the court number 13, explicitly mentioned that you should pay the 50% allowance. Matter has been highlighted, and Learned Council, newly as council took 2 days time to inspection. Now that council has been against, new council has been sued, the Lordship kindly said the contact of the petitioner, my lord. And now he escape of the matter, want to do this petition, my lord.
Mr. Bhuya,
My lord.
have you gone through the order?
Yes, my lord, I have gone through, my lord. This is, my lord, what has happened, this is absolutely a, my lord, wrong communication had been advanced, my lord. Even that, my lord, we can file an affidavit also, my lord. This statement had been advanced, my lord, by the council with, my lord, with the information which is not in a proper, my lord. What has happened? The respondent number 7 herein, represented by my respected senior friend, is a TET teacher, my lord. Still working and continuing in the service. She is not eligible. No, I have not finished my submission, my lord. She is not, my lord, entitled under the pension rules to get any pensionary benefit. Now, my lord, the respondent number 7 and my late husband has a, my lord, child, my lord. For that child, 50% amount is excessive, my lord. That's why, my lord, I am not agreeing to pay 50% amount, my lord. And as my relief, my lord, has been granted by the government, this is my writ petition, my lord. It is my prerogative to withdraw the same. Now, if this order is not complied with, my lord, remedies are available with my learned senior friend can institute a contempt or can come up with a fresh writ petition, my lord. But he cannot debar me from withdrawing this petition, my lord.
No. You see, here, the matter is listed.
No, my lord, I have gone through the order passed by the passed by this
For
honorable
filing
court, my lord.
mutual agreement to share the
No, my lord,
amount
my
in
lord, my lord,
writing.
yes, yes, my lord, I am reading the relevant part, my lord. Considering the above controversy and submission made, the parties may submit their mutual agreement to share the amount in writing if so advised before this court. Now, my lord, that advice has not been advanced to the, my lord, petitioner, my lord. So that's why, my lord, this is not a binding, my lord, on the part of the petitioner, my lord. If this order, with all respect, my
No,
lord.
no,
with-
no,
my
Mr.
lord.
Bhuya, you see, on the submission made by the counsel for the petitioner,
My lord.
this observation has been recorded by the court.
No, that is
Now,
correct, my lord.
can
That
you,
is
are
correct,
you
my lord.
entitled to recite from the same?
No, my lord, I am not saying that, my lord,
Then-
my lord, what has happened, my lord, on that day, the instruction which has been put in to me, my lord, I will put an affidavit to that
Okay,
effect also. my
okay,
lord.
you file an affidavit.
Yes,
with
yes, my
same.
lord, I can file it, my lord. But, my lord, my prayer for withdrawal, my lord, is objecting, my lord, that is acceptable, my lord.
Lordship, I see order,
My lord.
that you have to mention. The learned counsel for petitioner submit that the petitioner is agreeable to the share 50%. My lord, on the basis of instruction, now he agrees, when another said council come and
No, no, my lord.
claim that has become this.
No, no, my lord, I am not
What
blaming,
can we do?
my lord, my lord, I am not blaming, my lord, I am not blaming my
He is
learned.
a lawyer, and other lawyer make a submission on the basis of instruction, my lord.
My lord, I am
My
not
lord, now
blaming
you-
my learned
not
friend
Mr.
also.
Bhuya, please.
My
Well,
lord, my lord,
That's it.
my
Well,
lord.
the law can see in affidavit. While the pension paper has been processed, I also filed an objection there. Then the authority did not disburse the amount. They filed the petition. Thereafter, they called for all the parties. The hearing was taken place. You will also kindly see my affidavit page 34. Page 34, my lord.
Send
My
it.
affidavit, my lord. All the persons were called for to notice issue. Date was fixed on 18/11/2024. It was reported upon that day all the persons are prepared. Then he made a commitment that I pay lump sum amount that was not expected by the authority. He said, then another will get filed. This I will pay 50. Thereafter the amount has been released to her account. Now after receiving the amount 25 lakh, so now they did not contact with us. They did not pay any single amount. Now when this matter is come, my lord, the one inspection, the just filing there, she stated that the situation is agreeable. Now the subsequently it cannot be give the blame and it cannot alter his submission, my lord. Alter the facts, my lord. So contempt may be done instantly, my lord. Not for making such submission, but
My lord, may I submit, my lord, if my learned respected senior friend allows me, my lord. My lord, what?
13, code number 13 is specifically
My
mentioned
lord,
in orally. You pay, must you pay. Then they only 2 days time has been granted, my lord.
My lord,
Now they have come with the good another kilometer.
My lord, what my learned senior friend is saying that I am blaming the earlier learned council, my lord, that is not correct, my lord. I am not blaming anybody. My lord, this lady,
No,
my
Mr.
lord,
Bhuya,
my lord.
you have submitted that the earlier council was not instructed to submit
Properly,
in the
my lord.
manner that
Yes,
has
my
been
lord.
recorded in
Because
this
it is
order.
not on affidavit, my lord. It is not on affidavit, my lord. We will put
You
it on.
file an affidavit.
Yes,
we'll
yes, my
see.
lord. We will put
Or
it on affidavit, my lord.
Mr.
What is
A.R.
the
Bhuya,
facts and
learned counsel for
circumstances,
the
my lord, we will
petitioner.
put, my lord.
Mr. Bhuya submits that he has been engaged
My lord.
today by the petitioner and that he has the instruction to withdraw this petition. However, Mr. J. Ahmed, learned counsel for the respondent number, you are for respondent number 7, has vehemently opposed the petition on the ground that on 17/11/2025, this court was pleased to direct the parties to submit their mutual agreement to share the amount in writing, if so advised before this court, and without filing such mutual agreement, if the petitioner is allowed to withdraw this petition, then serious prejudice will be caused to the respondent number 7. In that view of the matter, it is provided that Mr. Bhuya, learned counsel for the petitioner, shall file an affidavit to that effect
The exact position, Milord.
exact position,
Mile.
fixing the matter immediately after reopening of the vacancy.
Yes, Milord. Oblige, Milord.
Can I do 32 promotion?
May it please your lordship. My lord, I am sorry I was not there. The order impugned is at page, my lord, 35. Is deemed to be absent from the date from his duty with effect from the date of arrest.
When the order was passed?
Order was passed on 11/12/25, and I was arrested on, my lord, 11/9/2025. And it has been given effect from the date and time of arrest. That is first paragraph, last line.
So when you have been released from jail?
My lord, I was released from jail, my bail application 23/10/2025.
23/10/2025. And when did you inform the authority about your release from the jail?
My lord, here my application is at page, my lord, 33.
Page 30,
3.
33.
That
On
is
which
date
date you
purpose.
filed the application?
My lord, to the Commissioner Secretary, Government of Assam, 3rd December 2025.
3rd of December
2025.
2025.
And my lord,
Informing
this,
him that you have been released on bail by the court.
my court. My lord,
So this 90 days period
90
shall
days,
be counted from which date?
my lord, my understanding goes because both the division bench held in case of a deemed arrest, that 90 days, Ajay Chaudhary will be taken into consideration. The division bench of this court.
No, another decision of a coordinate bench of this court is there that it should be counted from the date of communication of the release from the jail.
But no, my lord, it will be because my suspension is with effect from the date of arrest.
Mm.
Because my suspension goes and it will be counted paragraph 1 in the page 35 and is deemed to be absent from the duties, from his duties, absent from his duties with effect from the date and time of arrest. So, my lord, I will be not in job for the absent of that particular period. From
No,
90
that's
days.
all right. But though
My
our
lord, this is what,
police
my lord,
then
division bench para 13, my lord, has held, my lord. Your lordship will look into it. 2 division bench judgments are there, my lord. Rakibuddin to jail. And Rakibuddin to jail. It is it.
and whether the charges under which he has been arrested relates to the discharge of his official duty.
My lord, PC Act is there, my lord, in this chart. PC Act is. Here, page 26, your lordship will find. Some lady, my lord, impersonating my office has done something. That is the only allegation. Your lordship will find at page 26. Main accused is somebody else who in sitting in my office has done something wrong. That is the allegation, page 26. Named accused is somebody else, Rehana Khatun. And the bail order is at page, my lord, where also it reflects. Page 30, it starts at page 30.
Yes, Mr. Bora, do you have any instruction on this one? You have to obtain instruction.
Only thing my prayer is, my lord, let it come in motion, my lord. On instruction, let it come on motion.
Okay. Third, Mr. Roy Chaudhary, learned counsel for the petition. And also heard Mr. Bora, learned standing counsel for the respondent being Health Department.
For all the respondents.
For all the respondents. In this petition under Article 226 of the Constitution of India, the petitioner has challenged the notification dated 11/12/2025 within bracket Annexure 7, by which the petitioner is deemed to have been placed under suspension from service with effect from the date of his arrest in exercise of the power under Section 6 within bracket 2 under Rule Six, within bracket 2 of the Assam Services Discipline and Appeal Rule 1964. And also to issue direction to the respondents to reinstate the petitioner in service as senior medical officer cum district nodal officer of Civil Hospital, Golpara. And further, to dispose of the representation filed by the petitioner dated 3/12/2025. Mr. Soudhuri, learned counsel for the petitioner, submits that the petitioner was placed under suspension by notification dated 11/12/2025 with effect from the date of his suspension, not the date of his arrest. And further, Mr. Soudhuri submits that the petitioner was arrested on
10/9/2025. 11/9/2025.
11/9/2025.
2025.
And he was released from jail
On 23.
pursuant to an order passed by this court on
23/10/2025.
23/10/2025, and thereafter the petitioner has filed one representation to the respondent authorities for
3/12.
revocation of his suspension and reinstatement in service on
3/12. 3/12.
3/12/2025, but the same has failed to evoke any response from the respondent authorities. And as such, Mr. Soudhuri has contended to interfere with the notification dated 11/12/2025. Mr. Bora, learned standing counsel for the respondent authorities, however, submits that he may be granted some time to obtain instruction. Where allowed, recessal list the matter immediately after reopening of the vacation in the motion column. After vacation.
Extra. Date to দিব না দাদা? After vacation দেখুন date. After vacation দিছে আমার আইলো।
In this matter, Mr. Ajay Khatunia will appear not take up after some time. These objects in the court law. Okay.
Obliged.
Number 8, pardon matter.
May I please your lordship? Lordship, the conducting senior is out of station for personal difficulties. Kindly pass over the matter.
After vacation?
Alright.
Miss, your good name?
After BU vacation. Let it be after BU vacation.
Yes, yes. Your good name, please?
Yes, Sheikh.
Learned counsel, appearing on behalf of Mr.
PJ Fukan.
PJ Fukan, learned counsel for the petitioner. With concern from the other side, press for listing the matter after BU vacation. Where allowed, recessal list the matter on
27 January.
27 January.
Obliged, lordship.
Excluding number 7, lordship.
Okay.
As numbers 9 and 10.
My lordship, in this case, Mr. B. Porocasto is appearing, my lordship. He is on his leg. Kindly matter may be taken after some time.
Item. Eleven. Order matter.
None appears for the petitioner on call, list the matter after vacation.
Item 13.
For 9/10, lordship.
9/10 after some time.
No, lordship, actually, I'm seeing fine. Mr. Kumar said it's fine.
In this matter.
Oh,
Mr. Kumar.
Which item? Item 13.
9 and 10.
May it please your lordship.
It
is for 9/10.
9 and 10.
9 and 10.
It's a 9 and 10.
Oh, it's just, your lordship, possible for time being, your lordship. For the time being, as per instruction of B. Purkasta, the petitioner.
Actually, I am praying for an HMS, so Mr. Code is not available to me.
Did you inform the other side?
Yeah, lordship, we.
We'll call the matter. Let Mr. Purkasta come.
Much obliged.
Item 30.
Lordship,
Lordship, in item 13, I require for few more time, Lordship, because
You have filed your
board
affidavit.
meeting is yet to be taken place, Lordship.
Pardon?
Board meeting of the municipal board. I am appearing for the municipal board, Lordship.
Hmm.
So, on the last occasion, I appraised the honorable court that this matter will be placed before the next
Board.
board meeting. Yes,
Okay.
Lordship. So board meeting has not been held for last 2 months, Lordship.
Hmm.
I say the matter to be taken up after the Biku holidays, Lordship. Most probably in the month, this month and or at the beginning, Lordship, their board meeting will be held, Lordship.
Lordship, as per my instruction, one board meeting was held, Lordship, but then the outcome of it is not known
When?
to me. On 12/11, Lordship, 12/11/2025, Lordship.
12/11/2025. Is it correct, madam?
Lordship, I talked to Chairman, Lordship, he said that no board meeting has been held, Lordship.
I'm not sure, Lordship, then,
Okay, let it be after vacation.
Lordship.
Heard Mr. MP Sharma, learned counsel for the petitioner. And Madam Bhattacharya for respondent number
3 and 4, Lordship.
3 and 4. And you, Ms. Sharma for
1, 2 and 5.
1, 2 and 5. Ms. Bhattacharya, press for listing the matter after view vacation. As informed by the chairman municipal board. The board meeting will be held in between. Where allowed recessal is the matter after view vacation.
Lordship, may kindly give a date, Lordship.
Okay.
30, please.
I'm obliged, Lordship. My lord, I am sorry, Lordship, item number 11, Lordship.
Take it that from him.
Item 14.
May I please, your Lordship?
Before we start, I'm praying for an HMS, who is not available. He is unavailable.
Soon after vacation, my
Yes.
actually regarding monetary benefit.
Okay.
Reply has been already filed.
Heard Mr. Nath, learned counsel for the petitioner. Mr. Chakraborty for AZ and Mr. Your name? TK Ghosh, learned counsel appearing on behalf of Mr. Ward. K. Kaur, learned counsel. Learned additional advocate general. Mr. So-and-so learned counsel appearing on behalf of Mr. K. Kumar, learned additional advocate general submits that Mr. Kumar is out of station and press for listing the matter after vacation. After
May I
vacation,
pray for a date on 6th or 8th, my lord?
there
The
are
matter
no
could be
recessal
disposed,
list the
actually.
matter.
22nd January.
22nd.
Obliged, ma'am.
Item 15.
May I please? This matter pertains to appointment of a medical dresser. So the petitioner was a candidate there and he was not selected, but the private respondent was selected and the selection is under challenge because it is not made in terms of the advertisement.
Okay. Mr. Bora, is he present? Okay. DP Bora? After some time, let Mr. Bora come.
Fine.
Item 16.
After Vishnu Malan, in the
The Directorate Office Legal starts, was not found now, they are searching in the secretariat.
Okay, heard, Mr. You were here?
Yes, Lord.
Your name?
My senior, okay, there is.
Mr. Sigdar, Learned Counsel for the petitioner, Mr. S. Duff, Learned Standing Counsel for the Education Department. Mr. Abedin for respondent number 7. Respondent number 7. Who is you were appearing for respondent number 3 and 4. Ms. Bowman for respondent number 3 and 4. Mr. Das, Learned Standing Counsel for the respondent number 7, so submits that though there was a direction to produce the record, the same could not be traced out and he pressed for listing the matter after vacation so that he may produce the record before this court. We are allowed to list the matter on
21st January.
21st January. 20.
17.
Yes.
In this case, instruction is still available. And 4 weeks time to be granted.
Lordship, it's a matter of 2023. More than 2 years have passed by. They are unable to obtain instruction for 2 years. Probably your Lordship will proceed on the basis of materials available on record. Even on last occasion, Lordship, in 2022-11-2024, 2 weeks time was granted. Pending for the last more than 2 years now.
Last subscription.
You are for Agriculture Department. So you see, last order was passed on 22nd of November 2024. One year elapsed.
But I'm extremely sorry, but I think last time.
Will grant you time, but you have to pay some amount of cost. Heard Mr. Chakraborty, Learned Counsel for the petitioner, and Ms. Z. Bora. You Z. Bora, Learned Standing Counsel for the Agriculture Department. Ms. Bora submits that she has not received the instruction till date. But it appears from the record that the case was first listed on 29/9/2023. And notice was issued on the same day. And thereafter, more than 2 years elapsed. But the respondent authorities have failed to file their affidavit in opposition. And today, again, Ms. Bora submits that she may be granted some time to obtain instruction. Where is allowed, subject however to payment of cost of rupees 5,000, which shall be deposited.
Last time.
Sorry. Which shall be deposited in the Welfare Fund of Guwahati High Court Employees Association before next date. List the matter on
27 January.
27 January.
Item 19.
My lordship, B. Purukastu will appear in this case, my lordship. Kindly may be taken after sir. He's in court number 4, my lordship.
Item 21.
Granted a 4 weeks more time to comply with the order.
To comply?
With the order, your lordship, order dated 8/12/2025.
No. In this order, There was no direction as such
But this is the instruction
for
that
compliance.
17 years they adopted.
Hmm? The direction was only to obtain the status of the suspension order. Whether it was reviewed.
And the second sign is answer is open type, so it's both. The council open. So taking instruction from the department.
So Mr. Bhuya, you have been placed under suspension on 27th of December 2013.
My lord.
Since
lord.
then, it has not been reviewed
No, my lord.
and also not been revoked.
No, my lord. And even my subsistence allowance has also not been paid, my lord. That's why, my lord, on the last occasion, my lordship was kind enough, my lord, to direct them to pay at least the subsistence allowance, my lord. And my lord, I am at now around 57 years of age, my lord. Very few days left, my lord. My lord, actually suspension was due to a criminal, my lord, case registered against me. Thereafter, my lord, I have been acquitted, and that acquittal order, my lord, I have annexed also, my lord. My lord, may be pleased to find is at page 42.
No, after you have been placed under suspension, whether any DP was drawn
No,
up?
no, my lord.
No.
Nothing, my lord. They are in total, my lord, deep hibernation, my lord. No action has been taken, my lord. Basically, my lord, as per the law settled by the Honorable Apex Court in Ajay Kumar Chaudhary's case, my lord, this suspension is now not in force, my lord.
So therefore,
My lord.
they were directed to obtain instruction to obtain the status of the suspension order.
My lord.
But they have been praying for time. What time is required?
According to the instructions received, 4 weeks times person.
Sorry.
They can pay, at least release my current monthly subsistence allowance, my lord, for my, because, my lord, I am ailing also, my lord. Serious issues are also there, health issues, my lord.
But you have approached this court lately.
Yes, my lord. That is because, my lord, as the criminal trial was going on, my lord, I had an impression, my lord, I have inquired to the petitioner. My lord, he says that as the criminal trial was there, so along with me.
Part Mr. A.R. Bhuya, Learned Counsel for the petitioner. Ms. Terangpe, for the respondent in secondary education department. Ms. Terangpe has produced 2 letters. Now 1 letter and 1 order.
Letter, only this one.
Passed by the written by the Director of Secondary Education and also passed by the Director of Secondary Education. And she applies for granting 4 weeks time. 4 weeks time. It is to be noted here that by order dated 8/12/2025, the Learned Standing Council was directed to obtain instruction in respect of the status of the suspension order. And further, there was a direction to release the subsistence allowance of the petitioner. Forward, taking note of the submission of Ms. Rangpi, the matter stands adjourned to be listed on COVID.
On 27th.
Sorted. First week of January.
Agent.
8 January, so as to enable Ms. Rangpi to obtain instruction in respect of the status of the suspension order and also in respect of payment of subsistence allowance to the petitioner.
Mal.
When-
Obliged.
15th.
That was there.
The private respondent is there, my lord. Private respondent is there and he has,
Yeah, I've challenged the
elections the private respondent, my lord.
Okay. But whether you have obtained instruction
My
as per
lord,
the latest order,
I have not obtained,
why?
my lord, I have communicated sometime will be granted, my lord, I obtained.
It's an old case, my lord.
Mr. Bora, you say the last order was passed on 16/6/2023.
Yes, my lord.
2 years. 2.5 years.
Yes, my lord. I will follow up, my lord.
Heard Mr. Laskor, learned counsel for the petitioner. Mr. Bora, learned standing counsel for the respondent. In Health and Family Welfare Department, Mr. Bora sounds that he may be granted some time to obtain instruction. Accordingly, a last opportunity is granted to Mr. Bora to obtain instruction as or more than 2.5 years back, he was directed to obtain instruction. By order dated 16/6/2023. None appears for the respondent number 3. Though one counsel has entered appearance by filing Galanama. Place the matter immediately after reopening of the vacation.
Date may be given.
19.
19.
Item 20.
Obliged.
Item 21.
21. 21.
Obliged.
Item number 22.
Who is appearing for the applicant?
Applicant is the impleadment. Interlocutory applicant, your lordship. Not there.
Mr. A.K. Das. After some time, let the courtmaster
Yes,
contact him.
much obliged.
Item 23 and 24.
May I please, lordship? My lord, this contempt case was filed, my lord, in connection with the order dated 24/9/2024, my lord, page 11. And my lord, operative part, page 15 and 16, my lord. There is a, my lord, clear direction, page 17 and para 15 and 16.
So Soikia, you have filed your reply here.
My lord, I filed it. my lord.
And my-
12 I filed.
And my lord, I have filed also, my lord, reply in affidavit, my lord, page, kindly turn to, they, my lord, filed one IA, my lord, for my lord, seeking permission for review the order, my lord. And in that IA, my lord, kindly turn, see our, my lord, affidavit in reply, my lord.
IA for?
They have filed, my lord, IA for seeking, review, my lord. Review petition, filing review petition, my lord. So, my lord, what is the motive for filing this IA, my lord? Kindly, my lord, take a note of our, my lord, affidavit in reply, my lord. Affidavit in reply, my lord, I have annexed the order sheet, my lord. It starts from page 41.
My lord. That I, my lord, find the managing committee, not by the respondent of filing.
Managing committee, my lord. But my lord, if my lord, your lordship see, my lord, the order sheet, my lord, 24/5/1/11/2024, the I was listed on that day, my lord, on the prayer of being made by them by Mr. D. Kolita, learned counsel for the applicants, registry shall list the matter after a week. Again, my lord, order dated 19/2/2025, on the prayer of Mr. D. Kolita, learned counsel for the applicant, list the matter after 2 weeks. Again, my lord, order dated 9/6/2025, Mr. D. Kolita, learned counsel appearing on behalf of the A.K. Sharma, learned conducting counsel for the applicant, pays for listing the matter after a week. Again, my lord, kindly, my lord, turn to page 48, order dated 4/8/2025, on the prayer being made by Mr.
Today,
D.
Mr.
Kolita.
Kolita is absent.
Yes, my lord.
Applicant is absent.
Motive is that, my lord, to delay, my lord, our, my lord, to, my lord, deny our pension, my lord. That is the motive for filing this IA, my lord. Nothing else, my lord.
Respondent, we are filing the IA. Equality is present, lordship.
So, my lord, why, my lord, this IA was filed to deny my pension, my lord. Since, my lord, 24/9/2024, I am waiting, my lord. Within a 1 week, my lord, my doyle and non-doyle certificate was directed to be issued. At that time, my lord, respondent number 5 was the in-charge principal of that, my lord, higher secondary school, my lord.
So you have not yet received the pension and
No, my
pecuniary
lord.
benefit.
Some dispute is there. That is why, my lord, 25% amount was directed to be hold, my lord. So 75% was, my lord, directed to be allowed, my lord, give, my lord, but that has not been done. So, my lord, I am helpless, my lord. In such is, my lord.
So, why the amount has not been released?
Lord, it's stated, my lord, that PP order issued, my lord. And PP order is a committee, managing committee, school managing committee, they have issued it, they have to issue the non-dwell certificate. And that non-dwell certificate have to be submitted before that assignment. That part, my lord, we have nothing.
That non-dwell certificate has not been
Non-dwell
issued,
certificate by the management committee.
not been issued.
That has not been issued. Therefore, they file this IA matter. And petitioner claim that the pensionary benefits, my lord, other benefits, my lord, we have in this process, my lord, today probably upload will be completed, my lord, regarding the pensionary benefit, my lord. That has already under process, my lord.
100%.
100%. And my lord, that due to the non-issuance of the managing committee, my lord, therefore we could not comply with the orders of the honor report, my lord.
May I clear, my lord, one point, my lord?
Who is Mr. Kolita?
My lord, he is-
You produce this no objection certificate. Why the amount could not be paid? No objection certificate. You produce the no objection certificate before this court.
He have alleged that they are well this time, my lord. Therefore, they are not issuing the non-dwell.
That was considered during the pendency of the repetition, my lord. That is why 25% was directed to be held.
Where is Mr. Kolita?
No, lord.
Some time may be given
No, you ask him to produce the no objection certificate before this court by tomorrow at 2 p.m. You ask him.
Highly obliged, highly obliged.
25 and 26.
May I please your lordship?
Yes,
The judgment of the honorable single judge confirmed in the appellate judgment has
yes.
not been complied with, my lord.
Hmm.
1 year has expired. My lord was pleased to fix the matter today, and government was supposed to bring some instruction.
Mr. S. Das. Sarma, please inform. Wait for some
lord.
time.
27.
May I please your lordship? In this matter, lordship, there is some subsequent development, lordship. After filing of this writ petition, lordship, we need some time to brought on record, lordship.
We already people have been issued because earlier they should have given a copy to also instruction.
Yes, lordship, we need, because lordship, they have.
Lordship may. Otherwise, it is nothing wrong because it is having down on the recovery.
Recovery order, lordship.
Already we have said that there will be no recovery.
There will no, there will.
There will be no recovery.
Hmm.
That you will get 1,50,000 more. Because there is a difference between. Lordship can.
No, yes, sir. Yes.
If you want to take time, we don't have the mercy.
If your lordship may please to set aside the recovery order, lordship, that is.
How it can be.
That is your
No,
lordship.
if there is no recovery order, then
No,
how can we set aside?
No, lordship, we have not received any communication from the AG, lordship, regarding recovery.
Mr.
lordship.
Barua, furnish a copy to him.
Yes, lordship.
Have
This
given
letter.
the Furnish he wants from AG to him. Well, then we will give him to this one. Let him submit that way.
Lordship.
Because lordship already.
Art-
where
art
your
Mr.
lordship is
NK
here.
Sharma, lordship. NK Sharma.
N.K. Sharma, learned counsel for the petitioner, and Mr. C. Barua, learned
For 345 meter.
standing counsel for the respondent number 345.
345 AG.
Mr. Barua has produced one letter dated 8/7/2025, written by the senior account officer, legal cell of the respondent 345. Respondent number 345. And on the basis of said letter, Mr. Barua submits that PPO has already been issued to the petitioner.
Yes, fresh
What is press people?
PPO order has been issued.
Fresh PPO has already been issued to the petitioner, fixing the monthly basic pension at rupees 40,750. And Mr. Barua also submits that there is no recovery now to be made from the pensionary benefit. Instead, the petitioner will receive additional amount of rupees 1,50,000. That is the difference between his admissible DCRG and the provisional DCRG, which was paid by the department earlier. In view of the submission of Mr. Barua, learned counsel for the respondent number 3415, the learned counsel for the petitioner is directed to obtain instruction from the petitioner and release the matter on
Lordship, 7th of January, lordship, subject to convenience.
7th of January.
Deeply obliged.
Anything to submit?
One is lordship, the instruction that I received lordship. On behalf of one and lordship.
So the pension has already been finalized by
Yes,
the,
lord.
and PPO has been issued, and there is no recovery also.
Yes, lordship. This
Uh,
should be done by the president.
Okay, okay.
It's not for
Uh,
us.
let him obtain instruction, on next day we will close the matter.
Lordship. Deeply obliged.
28.
May I please your lordship? Lordship, the finance department is now before your lordship. But there is an order passed in the writ proceedings by this honorable court, whereby, my lord, the direction was that the departmental proceeding that is pending against the writ petitioner has to be completed within a period of 120 days, 120 days from the date of receipt of a certified copy of the order passed by this honorable court in the writ proceedings. That lordship will find, my lord, at page 20 of my interlocutory application, the direction contained in the order.
Page?
Page 20, my lord, 20 of my interlocutory application.
Yes.
Now, my lord, that timeline was fixed. Now we have filed this interlocutory application seeking a further time, my lord, to comply with the direction of this honorable court passed in the writ proceedings. The difficulty here is that, my lord, two departments are involved. The officer, the delinquent officer, that is the writ petitioner, my lord, he is an employee of the finance department. But at that relevant period of time, when he was deputed and working in the social welfare department, these anomalies were, my lord, detected. And accordingly, the departmental proceedings were initiated. He came before this honorable court that, see, the departmental proceedings are not concluded and I am not getting the pension. So therefore, this honorable court directed us, my lord, the finance department, to conclude the departmental proceeding within a period of 120 days. We have thereafter written communications to the writ petitioners that now the documents have been retrieved. So please come and participate in the departmental proceeding, which he has refused to come. But now, of late, my lord, I have taken the instructions from the finance department that he has now of late participated in the departmental proceeding. And this departmental proceeding will be completed. It is about to complete, my lord, within the next period of 1 month. So under that circumstances, if lordship may be pleased to dispose of this interlocutory application, giving us a liberty to complete the departmental proceeding within next 1 month from today, my lord, that will make the ends of justice.
Yes, Mr. Bora.
And on the last occasion, my lord, my learned colleague appearing for the writ petitioner, that is the opposite party out here, he had prayed for filing a written objection. The written objection has not yet come.
My lord, I vehemently objected my learned claim stated before your lordships. Half of the order. He is not given the entire specific, what is specific direction, my lord. He has given only their part only. They are going to comply. This miscase was filed, my lord, only 4 months have been paid. Already four months have been lapsed, my lord. Already thereafter this 2 days came before the honorable court. He is seeking only 6 months. But before going to that, your lordship go to the order, my lord. Page 20. He has not reading properly, my lord, I think. May I read, my lord? Para 49. May I, your lordship, page 20 of the IM. I file objection is there or not, I don't know, my lord. I not think. The page 20, my lord, your lordship.
Yes.
Para 14. This repetition is therefore being disposed of by directing the respondent to conduct and conclude the departmental proceeding within a period of 4 months, i.e. 120 days from the date of receipt of the certified copy of this order. Facilitating the above the concerned department to transmit the relevant records as expeditiously as possible. It is made clear that if for any reason whatsoever, the departmental proceeding is not concluded within the timeline provided by this order, the respondent shall finalize the mention of the petitioner within 4 weeks, but wrong time. Thereafter, release all his outstanding dues. That part, my lord, is not stated before your lordship today. I have
No,
already
that pensionary benefit has not been released to you.
not been released, my lord.
And thereafter what happened, they sitting over the matter, I filed a contempt petition. After receiving the contempt petition, he immediately came before the honorable court to filing this petition. And what happened, my lord, during this, my lord, the last 4 months already, my left, this order has not been disposed of at this petition. My lord, he called me to appear before the IO for inspection, my lord. And thereafter, my lord, I appeared, my lord. But regarding departmental procedure, regarding pensionary benefit is concerned, they have not done anything, my lord, till today, my lord. There is a specific direction. If you have not completed within 120 days, you have to pay the all pensionary benefit as well as service benefit. Now, my lord, my lord, your lordship, my objection is there, my lord.
Okay, okay.
Thereafter, my lord,
Okay, okay.
I came before another writ petition was filed, my lord.
Okay,
I filed
yes,
writ-
Mr. Borpuzari, you say there are two parts in the order. One part is relates to completion of the departmental inquiry within 120 days.
Absolutely.
And in the event of failing to conclude the same, you have to pay the pension and pensionary benefit.
Pensionary benefits.
So what is the status of that part?
Now, my lord, my humble submission is that, my lord, pensionary benefits, if it has not been paid, assuming, my lord, if it has not been paid, now my instruction is that, my lord, he is getting provisional pension. There is no.
The pension is not confirmed, my lord. After suspend, after.
No,
Bharat, please sit down.
I need a protection, my lord, right of audience. I never, my lord, spoke. And so, twofold directions, my lord, lordship has seen it. You conclude the departmental proceedings within a period of 120 days from the date of receipt of certified copy of the order. And then, if the pensionary benefits are not finalized, you finalize the pensionary benefits and pay him all pension. That meaning thereby you have to pay, I have to pay him the regular pension, not the provisional pension. Now, the fact that he is not getting a regular pension in terms of this order is a issue to be decided in the contempt proceedings. If I have defaulted, my lord, therefore he has stated, my lord, he has stated right now that he has already laid a contempt proceeding before this honorable court.
That
We are-
proceeding is pending before this.
Yes, yes,
contempt
that
proceeding?
is pending. It is his statement. Now, so far as this interlocutory application is concerned, because since I am moving this interlocutory application on a limited issue, I am only praying for a further amount of time, my lord, to complete the departmental proceedings. Heavens will not fall down if, my lord, I am not being granted a further time of, my lord, 4 weeks with effect from today. Let the authorities, my lord, lordship will be pleased to dispose of this interlocutory application. Let the finance department, secretary to the finance department, who is the applicant out here, my lord, they will complete the departmental proceedings within 31st of January. That much only, my lord. Because in between what had happened, the annexers, my lord, the documents appended to this interlocutory application will demonstrate, my lord, that we are so much in a tight situation, my lord, because the records have to be procured from other departments. We have written, my lord, letters to the, my lord, to the honorable special judge, my lord, for getting those documents, because these are part of vigilance cases.
Mr. Bora, regarding the non-payment of regular pension, that has to be dealt with in the case of the contempt, in the contempt case.
Yes, madam. But
Here, the
he has
only there is.
repeated the second, my lord. So thereby, I already another repetition is pending, my lord. There is an order, your lordship. Good, your lord, para 9, my lord. Para 9, my lord, order to be. Para 9, my lord, your lordship. Another repetition.
No, no.
No,
Mr.
my
Bora,
lord, that
you
is
say.
specifically stated by this coordinate bench. You cannot dilute that particular, my lord, second part, my lord. That is the order, my lord. Para 9, my lord.
No, no, that has to be dealt with in the other two petition. That is the contempt petition and this writ petition.
My
Here, the issue is only for extension of time to complete the
Only that
department.
much.
That is not there, my lord. Because of that, this IA is fine, my lord, your lordship, pair to the IA, my lord. Your lordship go to a pair of the IA. His
Yes.
pair.
Yes.
His pair says, my lord, para 9, my lord, page 9, my lord. Your order, so order letter so and upon causes being shown and upon hearing the parties, your lordship will be pleased to grant further time at least 6 months to the applicant, which effect from 22/8/2025. Already 4 months have been gone by. Nothing they are doing. All department are all already completed, my lord. Report was not, why report was not submitted? Why they were not sitting about the matter till today, my lord? I am appeared, everything statement was taken.
No, can we adjudicate those issues in this petition? This
My-
interlocutory application?
Interlocutory petition, he has praying for extension of time with effect from 22/8/2025, my lord. Already.
No,
4 months
that's all
they are
right.
dead with the sitting with the
Now,
matter.
since the matter is sub judice, without leave of the court, they cannot go ahead.
No, my lord, there is a specific say that para 9, you cannot dilute the regarding pension and GPS.
No,
or
where he has been praying for diluting the other part of the order.
Yes, my lord, because of
How?
that.
How?
How, my lord?
Then
Because
that
of
has to be,
That particular.
no,
my
no,
lord,
that has,
pensioner-
no, Mr. Bora, that has to be looked into in the contempt petition, not here.
My lord, he has.
Then you have also filed another writ petition.
He has praying before this honorable court for 6 months. This petition, I have filed before 4 months back, my lord.
No, that's all right. Unless any order is passed, can they go ahead with the matter?
Yes, my lord, he
How?
has to, my lord, because of.
How?
My lord, that is, my lord, so they have.
No, you tell me how they will proceed with the matter without leave of the court.
That he has to pass the departmental authority can dispose of the entire proceeding.
That
because
will
of
be looked into in that writ petition filed by you, not here.
that petition is coming before your lord. before
Yes,
the-
please sit down.
My lord.
Heard Mr. Bopuzari, learned counsel for the petition. Mr. N. Bora, learned counsel for the respondent, opposite party number 1. This interlocutory application is referred by the secretary to the Gupta Assam Finance Department. Oh. The seeking at least 3 months' time with effect from 22/8/2025 for complying with the direction issued by this court in the order dated 6/3/2025 passed in WPC number 409 of 2023. Mr. Barpuzari, learned counsel for the applicant, submits that though a coordinate bench of this court in WPC number 409 of 2023 by order dated 6/3/2025 has directed to complete the departmental proceeding against the respondent opposite party. The same could not be completed, and as such, Mr. Borthakur submits that further 4 weeks time may be granted so that the departmental proceeding against the opposite party can be completed in the meantime. Mr. Bora, however, learned counsel for the opposite party, however, vehemently opposed the petition on the ground that the order dated 6/3/2025 comprises of 2 parts, and the other part of the order, there was a direction to pay the pension and pensionary benefit to the opposite party if within the period of 120 days, the departmental proceeding would not be completed against the same, against the opposite party. And that part has not yet been complied with. But Mr. Bora has also submitted that one contempt proceeding being contempt case number. What is the number of the contempt case?
First contempt case number. Number 460 of 2025.
463 of 2025, and another writ petition being WPC number
WPC number 5785.
5785 of
Another order
2025
also passed, my lord. There are consequent order will pass.
has also been filed by the opposite party hearing. by the opposite party hearing. And in that view of the matter, the non-compliance part of the order dated 6/3/2025 has to be adjudicated in the contempt case number so and so, and also in the WBC number so and so. Here, the only issue is extension of time for completion of the departmental proceeding that has been pending against the opposite party. In view of the submission of learned counsel for both the parties, and also considering the facts and circumstances on the record, this court is inclined to grant further 4 weeks' time to the applicant hearing to complete the departmental proceeding initiated against the petition, against the respondent opposite party number 1. In terms of above this, IA stands closed.
And so obliged, my lord.
Much obliged. Platform 4 is 30 days. Otherwise, in a day is not much.
4 weeks, 30 days, is there any difference?
Yes, madam. Sometimes it's different.
How?
Because of that, sometimes your lordship pass the order matter is after 4 weeks.
Hmm.
But that matter is not come more than 6
No,
months.
that 4 weeks and this 30 days, there are different.
So I am a specific.
Sorry.
30 days. man.
Sorry.
Or 35 days, my any.
Sorry.
Not less.
May I please, your lordship? My lord, the connected MSC appeal was disposed of by directing the insurance company to pay a compensation of 10,85,000 on 28/2025, my lord. In the month of September, the insurance company deposited an amount of rupees 40 lakhs odd amounts. Our calculation is that the amount is a short payment, my lord. Around 3 more lakhs will be payable, my lord. So if they can give a calculation as to how they have calculated, we can point out.
May I please, Your Lordship? I am appearing on behalf of for respondent number 1. 10 days time may be given to for obtaining instruction, right?
No, whether we can reopen the issue after
My lord,
judgment being passed by this court,
my lord, I am not disputing the judgment at all.
then
What I am saying is there is the judgment has not been complied with. The amount that they have paid is a short payment. I'm not touching the judgment at all, my lord. We are satisfied with the judgment. The amount calculation that they have made and made the payment
no,
is a short payment.
they have to make the calculation as per the direction of this
Exactly,
court.
my lord. That's what we want to know.
Yes.
Let them produce the calculation, my lord.
I will obtain instruction, Lord.
But have you received a copy of the petition?
Yes,
Yes.
yes.
Where is the wrong
Instruction
in
कौन-
calculation?
ये बोला सर इंस्ट्रक्शन कौन तुम इंस्ट्रक्शन क्या है
Instruction. I am taking instruction, Lord.
Heard Mr. B. Prasad, learned counsel for the applicant. Then Mr. Dotto
And
for the respondent. For the respondent opposite party. This interlocutory application is preferred by the applicant. For issuing direction to the respondent opposite party to comply with the judgment and order dated 28/8/2025 passed by this court in MSC Appeal number 208 of 2022. Mr. Prasad, learned counsel for the applicant, submits that after the judgment being passed by this court, the respondent opposite party had paid a sum of rupees
14,74,914.
14,17,000
4,914.
74,914.
14. 914.
14. But as per the calculation of the applicant, the amount ought to have been
17 lakhs. It would be 70 lakhs 20,000.
17 lakhs 20,252. And the applicant is entitled to a sum of rupees 3 lakhs 14,524 rupees more than the amount paid to
This
the
would be as
applicant.
on
To the applicant.
26/9/2025.
Pardon?
This amount would be as on 26/9/2025, the day when they made the other payments.
Okay, as on 26/9/2025. 2025. Mr. Dotto, learned standing counsel for the respondent opposite party, however, submits that he may be granted some time to obtain instruction. Where is allowed, this is a list the matter immediately after reopening of the vacation.
May I please your lordships? Page 14 start for judgment lordships. So for the 27 is the direction part. And last order is 24/11 or 25. They assure to place again my case. Direction is dated lordships 16/6/2023 to comply within 2 months. They're buying time. Page 27,
Where
paragraph
is, where
39.
is Mr. Sisti, SMT Sisti?
Three, four persons' names appeared.
Let Mr. Sisti come at 2 p.m.
I got 14.
Lordship, today I have filed ballot number. I saw respondent about 12/60/20, 20 to 23, 26, and 27, 28. I need some time to lordship to file decline.
That's what 30.
Heard Mr.
Lordship.
H.S. Laskar, learned counsel for the petitioner, and you for,
Respondent number 19, 21, and 28. Lordship.
you give it in writing to the court master. Your name, please?
R. Islam.
R. Islam.
Yeah.
For respondent number?
12, 16, 18, 20, 22, 23, 26, 27, 28.
And he submits that he has filed his Ukalat number today and he may be granted some time to file affidavit in opposition. Pair allowed, recessal, list the matter after vacation?
Yes.
After 4 weeks. After 4 weeks. Service in respect of all the respondents completed?
Maybe all the respondent not completed. I'll file, I'll take Dusty, my lord. I will file affidavit, my lord.
The learned counsel for the petitioner submits that he may be granted some time to file an affidavit to the effect that he has effected service upon respondent number?
Respondent number 11 to 27, my lord. I have already taken Dusty, my lord. I will file affidavit.
Respondent number 11 to
11 to 28.
20.
28.
28. And he will file the affidavit within before next date.
Next.
Fair allowed, recessal is the matter after 4 weeks.
Most of it.
Or Thailand. One was a video. Password. Or
May I take
At
your
2
lordship?
at 2 p.m.
Lordship, just a mention, your lordship, taking indulgence from your lordship. Item number, your lordship, 25 and 26 orders, contempt matters, your lordship. They have also not received instruction. My learned senior friend has some difficulty also in the second half. Maybe come up after Bihu vacation, your lordship.
20.
25 and 26.
After Bihu vacation.
As agreed by learned advocates of both the parties, recessal lays the matter after vacation. In the meantime, the learned standing counsel for the respondent contemptor shall obtain necessary instruction.
Necessary instruction.
Yes.
Deeply obliged, your lordship.
So your lordship, regarding item 980, the petition is asked for it.
I'm not seeking for adjournment.
I'm seeking for adjournment.
Yes, they are seeking.
9 Okay, Mr.
Already
Mr.
parted, my lord.
Professor,
Already
learned
hearing is
counsel for the
almost
petitioner,
completed.
and Mr. Learned counsel, AK goes learned counsel for the respondent. Number
So 9 and 10.
9 and 10. Mr. Gross submits that he may be granted some time to file affidavit in opposition.
Only for producing the records.
Only for producing the record. Producing the record. Pair allowed, recess is the matter immediately after reopening of the vacation.
But I attended 39, I couldn't API.
Hmm. Hmm.
So I have some difficult, I have to be, I have the instruction that the they'll be call in the next week. So I have also informed him, the matter may carry taken up immediately after vacation, lordship, at 39.
Yes.
Lordships.
Okay.
He's aware of the development.
Heard, Mr. Borbunya, learned counsel for the petitioner, and Mr. SMT Siste, learned counsel for the contender. Mr. SMT Siste, press for listening the matter immediately after reopening of the new vacation or
No, this.
First-
so winter vacation.
7 or 8. lordship.
Okay. Pair allowed, recessal is the matter on 7.
Obliged.
7.
7th. Obliged.
Until permission.
Yeah, please. But as per last order, my learned friend is to produce the instruction whether the deputy commissioner or district commissioner has the authority to suspend to invoke the power of my lord, disciplinary appeal rules 1964 against the petitioner, my lord.
Yes.
I do.
Is there any document to show that he is empowered to take action to take
Yes.
disciplinary action?
Next one, number 5. Yes, number 30.
Page number?
31.
Impugn order, my lord.
This is not an option. Paragraph number 3, your lordship. In page line, your lordship.
No, who empowered the district commissioner? Pardon?
He has suggested.
Suggested. And who had passed the suspension order?
There is no suspension order, my lord, the pay cut order.
Oh, pay cut order.
This is the impute order, my lord, whereby the deputy commissioner, the district commissioner, my lord, has directed to for pay cut as well as for shock cause. Had it been the only shock cause, that would be different, my lord, but the pay cut is followed by pay cut.
Okay.
And that pay cut is not a prescribed punishment, my lord, in the rule.
Yes.
That pay cut is not a, my lord, prescribed punishment in the rule, my lord.
Hmm.
Therefore, my lord, he's not only issued the directed the suggested the authority to issue the shock cause, as well as he has given the prescription of punishment. And on the basis of that, they have, without, my lord, following the rest of the procedure, they have directly issued the pay cut order.
Hmm.
That is the thing. And
There is no pay cut order.
last line,
That the report of the DC.
last line. Similarly, shock cause notices should be extended to all 8 teachers who were absent during the school hours, accompanied by a 1-day salary cut for each teacher. This is the order.
The report of the DC laws, the district elementary plan. Page number 32. This is the so called. The order is yet to be passed. The block officer also
They have deducted my salary, my lord. I have given the annexure 8A, page 8A and 8B, the 36 and 37. You will find in the page 36, salary is, my lord, 69,215 for January 24. And February 24, your lordship will find 66,828. It is reduced. Without passing the order on the basis of the direction of the DC, my lord, they have done it. And moreover, this is not a prescription.
Though it is not in the Assam discipline and appeal rule yet, it in
Rule 7,
CCA,
my lord.
there is one provision for
Pay cut,
no work, no
one
work,
day-
no pay.
Lordship, there is
There
no
is one
such, my lord.
provision in the CCS. No work, no pay. You go through the provision and come prepared.
Yes,
We'll
Lordship.
finally dispose of the matter on next date.
Because the pay cut order, my lord, DC has issued already without conducting the, my lord, the inquiry and without
No, he has visited the schools. He found you absent. There is no dispute about it.
dispute, my lord, with regard to my absent, my lord, I have given the explanation.
Hmm.
Without taking into consideration that aspect, my lord, my lord, they have issued the order and deduct, without order, they have deducted my salary. That cannot be.
By the British, page number 34.
Hmm.
Come to July.
Page number?
Page number 34. This is the reply
Hmm.
by the petitioner to the so-called.
Hmm.
To the BEO's in response to the so-called notice, I state the following. That today, that is 15/2/2024. Firstly, in the early morning, at the time of attendance, the students and their parents requested, Lordship kindly see, in the early morning, parents requested not to serve CMDM, that midday meal, Lordship. As they already taken khichdi in the early morning to the nearest puja pandal. It is a case of early morning. Because they did not serve the midday meal on that day. The petitioner himself being the headmaster was not present. In the early morning, they took khichdi. And the parents requested not to serve the midday meal. Can it be believed, Lordship? In
It
the early
was-
morning to the nearest puja pandal of our school, depending upon the situation, and I was bound to undeliver the midday meal on that day. Most of the students came without uniform and books. After cleaning the puja materials, the schools, they were totally tired and dirty. So the parents and students were requested that they wanted to leave the school after completing this. Parents also requested that they had puja at their own houses. After looking all the situation, I was bound to permit the students to leave the school. The person will see the reply.
This is just after the Saraswati Puja. It was 2 days Saraswati Puja celebration was there. One day it was done, my lord. This is the reason, my lord. And in the nearby pendal, there was
And
Saraswati
how
Puja.
many days are permitted by the government?
1 day.
1 day.
1 day. And that day as is observed. Subsequent day, it was, my lord, for removing all these materials, my lord, it was there.
Okay,
But
you
on that
come-
day,
Come prepared on that issue. There's no work, no pay, we will see. And you will obtain instruction as to whether any order has been passed by the district elementary education officer in respect of pay cut. Or Mr. Purkaso, learned counsel for the petitioner. Ms. Capricorn, learned standing counsel for the learned junior government advocate for the respondent number 3, and Mr. Sharma for respondent number 1, 2, 5, and 6. You for respondent number? Respondent number 4. Person to order dated 5/12/2025, Ms. Fukun has produced her written instruction before this court. Accordingly, taking note of the instruction and also the submission of learned counsel for both the parties, it is provided that Mr. Sharma, learned standing counsel for the respondent number 1, 2, 5, and 6 shall obtain instruction as to whether before the pay cut, the district elementary education officer has passed any order to that effect. And if it was passed, a copy of the same shall be produced before this court on next date. List on
22nd.
22nd November.
obliged.
Pending 22.
Yes, applicant is absent today. This IA? Yes.
For the IA lordship. Parties.
So whether notice was served upon opposite party number 6 and 7. Hmm?
Seven was not completed lordship. Correspondent number 7, being completed as respondent number 7 lordship.
No, you see here the respondent number 6 is the school managing committee and 7 is the treasury officer. Whether you have taken a step upon them. No step has been taken.
Steps.
Heard miss, your good name, please?
Yunanda, Lordship.
You Nanda, learned counsel for the applicant. Miss M.A. Oza, learned counsel for the opposite party number 1. And Miss Mosari for respondent number 2, 3, and 5. And Miss K. Fukon for the respondent number 4. Office note dated 15/12/2025 indicates that no step has been taken by the applicant upon respondent number 6 and 7. Accordingly, it is provided that the learned counsel for the applicant shall take fresh step upon respondent number 6 and 7. Not fresh steps, take step upon respondent number 6 and 7 by speed post. And also by usual process, the SSL lays the matter immediately after reopening of the vacation. You take step.
Timing 23 and 24.
May it please your lordship,
Hmm.
here is an information instruction from my client. They have with the same issue, they have approached the learned educational tribunal, your lordship, and it was their petition for implement was dismissed.
There.
Yes, your lordship. I have brought the certified copy of the order.
Better you file an additional affidavit.
Yes, lordship. Yes, lordship.
By bring on record this
Yes,
order.
Timing 23 and 24.
your lordship may be pleased to fix a date.
Take a date from him. Court master will give you the date.
23, 24.
Oh, funny to know, yeah. Okay. হেৰিটো নাহিল ন ই কলিতা ওলা কাইলে এটা হেৰি প্ৰডিউচ কৰিব দিলো নহয় হ'ব অৰ্ডাৰটো পাছ কৰি দিম কোনোবা আহিলে কৈ দিব খালি
Very minor. Was how for regular transport.
Oh, in fact, Mr. Patel is still on deck and perhaps
In the same case, my lord,
In
both
the
of
same
them,
case.
both of them in the same case after sunrise, my lord. They took it for
Item number 5 for order is stated.
Lordship, in this matter, I'm appearing on behalf of Mr. V. Gogoi. The last occasion, my lord, as per the last order, your lordship had asked him to bring the records. Accordingly, he has brought the records, my lord, but he is unfortunately in, my lord, court number 4 on next, my lord, in a medical admission matter, which is going on from the morning. He had requested me, my lord, to request the honorable court, my lord, that the matter be taken up on 6th of January. We have taken consent of both the parties. So if your lordship agrees, my lord, it's fixed it.
Yes, agreed by learned advocates of both the parties. SSL is the matter on 6th of January.
6th of January. Deeply.
Item 38. Order is stated.
Wait, please, your lordship, lordship, my senior is on legs in court number 14, lordship. Could the matter be taken up after some time, lordship?
I'll just place the.
We do not have any other matter.
I'll just place that because already completed lordship, that's the plan. He has given some judgment, I have to, lordship is on that day, says that they have to go through this judgment and give the reply, that's all. Nothing else.
Lordship, in that
So
case,
lordship, after that day, lordship, my learned friend has placed the matter so nicely. So, in my, when you briefed me the case yesterday, after they have finished the briefing, I thought let go through a book. And it is the autobiography of Nariman.
I got a line that Lordship Falin Nariman has written that he asks his junior that this person who is argued before the court, who is he? Then he said, he is X. He said, no, I have not asked for his name. From which chamber? Chamber matters. He said, when you go to the horse race, you always ask for the stable, don't ask the name of the horse. So he argued so nicely, and he's from a chamber where we have learned Lordship. So I thought that at that time, Lordship, there was no online, nothing. So the other side, when placed some judgment that, Mr. Datta, he was always say, he called the other side of the matter. He will tell you what happened to that case, finally. So after he has shown the judgment, all the judgment, so I tried in the online and all. I don't get anything. So I thought that that is the final thing. But then I remember the doctor tell me in those days that sometime you try, call the other side you tell the fact, what happened. So on that, Lordship, on that day, my learned friend has placed the case. 2018, Supreme Guwahati case 440. A judgment passed by Honorable Justice A.M. Budalwar. And he read the paragraph 3-4. And finally, he said that this person, the JB Law College, his case was allowed. And then Lordship is the copy of this Lordship, Yogen Sharma versus State of Assam.
Yes.
Let me read the paragraph 7 Lordship of that. As this case is disposed of on the motion stage itself, it is directed for the interest of the justice that the respondent number 4 and 5 also given an opportunity of hearing while considering the representation of the petitioner dated so and so. As agreed, it is ordered. Also, it's an agreed order. As agreed, it is ordered that the Principal Secretary of the Government of Assam in the Higher Education Department shall give due consideration to the representation of the petitioner filed on 11/1 within a period of 4 weeks from today. In doing so, he shall also issue a notice to the respondent number 4 and an opportunity of hearing, and petitioner be also allowed to place any material that may be desired in support of his case. Till such final order is passed, the removal of the petitioner as the president of the college shall not be given up. So, in fact, Lordship, I am cornered by this judgment when my learned friend and Lordship has rightly said that you have to give the reply to all this. So I thought what to do. So I tried my best, Lordship, and then Lordship Lordship, may please come to So my learned friend is not there. I again said, Lordship, nowadays it is very difficult, Lordship, sometimes to get the review order and all that when it is not there in the online in here. So I call the other side and then come to know that all these things happen, Lordship. So this is a review petition to this judgment, Lordship. On 5-4, Lordship, before Lordship first come to the order dated 21/3/2018. 21/3/2018. It is the motion order, Lordship, review. Mr. Mahanta, learned senior counsel states that at the time passing of the said order, the correct facts were not presented to the extent that at that time the petition was already removed as the president and the review petitioner was holding the fort of the president at the relevant point of time. As in our case, Lordship, but before the interim order passed, the other one has joined. And he hold the meeting and I have shown Lordship on that day, all the decision was taken. Because the stay order was given on 22nd. And the respondent number 6, he took this charge on 28, 20. So in view of such factual situation brought to the notice of the court, the last line of the paragraph 8 of the order dated 5/2018, that till such final order is passed, the removal of the petitioner as the president of the college shall not be given effect, shall remain stay. So initially on 21/3/2018, it was stay. Now lordship on the next day. Final order on 5/4/2019. Lordship may please come to the second page. Page 3. It is the 5/4/2019. In view of such argument between the parties, the court allowed the proposition modified and so and so to the extent that the final order is passed by the Principal Secretary, Government of Assam Higher Education Department on the representation so and so. The respondent number 5 in the writ petition, namely so and so, shall continue as the president of the governing body of the college. It is further provided that such continuation of the respondent number 5 in the writ petition shall be put up for such period till the final order is passed by the Principal Secretary as provided therein. Thereafter, either continuation of the respondent number 5 in the writ petition of so and so, as to whether the writ petition is to be continued as the president shall be provided by the Principal Secretary in order to be passed. It is further provided that as the continuation or the non-continuation of the writ petition and the respondent number 5 of the writ petition depends on the order to be passed by the Principal Secretary, it is directed that the Principal Secretary shall give a consideration to the representation of the writ petitioner that so and so within a period of 2 months from the date of received the certified copy. Accordingly, review petition allowed to the extent. So, if that order was not there, in fact, on that day itself, when I have seen this order, I thought possibly section, the rule and the EA was not there.
3.3 to 3.4.
Rule 3.3 and 3.4, both was not considered. I was confused little bit. But now, proceed this order, this is the final date. So in our case, lordship equitable relief is already the president has joined. It is connected. There is no representation from his side to the government, to Principal Secretary and all that. Now, lordship, the other judgment my learned friend is referred to. Lordship, I'm grateful, lordship, I have not seen this judgment my learned friend has shown. So I'm really grateful, lordship. This is directly to the my point, lordship, in my favor, lordship. I'm grateful. Lordship, lordship, please take the 2006 2GLR, page 516. Lordship, the para 1, lordship. So lordship will take note, this is an appeal filed by the state of Assam. This is an appeal filed by the state of Assam. Para 1. The appeal raises the following question. Whether the proviso to section 80 of the Mission Autonomous Country so amended compels the state government to remove member in the Interim General Council, Executive Council as the case may be appointed under section 80 at the pleasure of the government. 2. Whether the principle of national justice are required to be followed before passing the order removing such nominate member of Interim General Council or the Executive Council as the case may be. Para 2. The appeal is directed against the judgment and order learned single judge which allowed the writ petition filed by the respondent wherein challenging the order dated 30/11/24 passed by the state government, removing them from the Executive Council in exercise of the power conferred under section 80 of the aforesaid act. Learned judge took a view that the removal of the writ petitioner on the ground their unsatisfactory nature of work as executive member of the council is a stigmatic in nature and entails the civil consequences. My learned friend also argued yesterday many times lordship that civil consequences there. So the learned judge thus concluded that such an action could not have been taken without providing any opportunity being heard to the writ petition. Now para 3. This is the argument of the learned advocate. Para 3. Learned Additional Advocate General appearing for the state internally submitted that there is no notice required to be issued for removing the member of the Interim General Council or the Executive Council as the case may be, inasmuch as law does not provide for issuing such notice. there is no assured term for which the member of the executive council has been appointed and they hold the office during the pleasure of the governor. It was submitted that the view taken by the learned judge that the opportunity was required to be provided to the writ petitioner before the removal and replacement by others is erroneous one, para 5. Before we proceed to consider the submission made during the course of the hearing of this writ appeal, it would be appropriate to notice section 80 of the act which read as under. So, Lordship, it is quoted. The So, para 6, Lordship, I'll not read the whole thing. A bare reading it started. The last 3 lines below 3. Precisely for that reason, the proviso confers unfettered discretion upon the government to remove any or all the members of such interim general council or the executive council as the case may be being replaced by any other person of the government choice. The proviso does not admit any other interpretation. The individuals nominated as member to the interim general council and as well as executive council is a temporary measure till the general council is constituted in accordance with the provisions of the act are liable to be removed or replaced by the government at any time without assigning any reason whatsoever. Now, Lordship, on that day, my learned friend has referred to para 13. Before reading para 13, Lordship to read para 10. Then Lordship will get the what is the judgment. In so-and-so versus so-and-so, 2001 2 SCC 441, the Apex Court, while interpreting the provisions of the Nagpur Improvement Trust Act, took a view that once the doctrine of pleasure is applicable, neither the principle of natural justice should step in, nor any question of giving any opportunity before removal would arise. We are of the considered opinion that the doctrine of pleasure was duly incorporated and implicit in section 80 as well as in the provisions to it. Now, Lordship, I will read the para 12. The pleasure, Lordship, before I read para 12, para 11, 4 line, I'm skipping 4 line, para 11, in just below the precedent B, Lordship, whether in a given situation, the stated rule is fully applicable or not, or whether any restriction or limitation are placed on the exercise of the pleasure, and whether those restrictions must be given effect to may depend upon this statutory scheme. In a given case, if there is a breach of restriction imposed by the statute, by the government, the matter becomes justiciable, and the party aggrieved may be entitled to suitable relief at the hands of the court. Now, he has read the para 13, Lordship, will skip. Now, Lordship, now I'm reading para 12, Lordship. Pleasure of the government is no way controlled by any provisions under the statute with which we are concerned for the present. There is nothing to suggest excluding from the operation of the absolute doctrine of pleasure. There is no restriction imposed upon the state government in whatsoever manner and structuring the exercise of pleasure. Now, para 15, Lordship. Before that, para 14, Lordship. The para 14, it was just yellow. Let me place. Be that as it may, whether the impure notification replacing the petitioner is stigmatic in itself, the notification by itself does not cause any stigma or any of the petitioner. The government exercises power merely replacing the petitioner with another set of individual without assigning any reason whatsoever. But the contention was the so-and-so that the state government with the following effect. I have honored to inform you that I am totally not satisfied with the work of the following vice chairman and executive member. As such, I would like to request you to pass necessary order to drop above mentioned vice chairman and so or meeting autonomous. Now, Lordship, the para 15. Now, Lordship will remember this is an appeal filed by the state against the writ petition. The impugn notification does not suggest that the power to replace the writ petitioner has been exercised based on the said letter. In such circumstances, using the veil of impermissible, and the court cannot presume that the impugn notification will be issued on the said letter. But even otherwise, now, Lordship, but even otherwise, the letter dated 29/11/2004 referred to herein above does not cast any aspersion and stigma on any of the writ petitioner, expressing one's dissatisfaction in no manner cast any stigma. 16. For all the above aforesaid reason, we find any merit in the writ petition, and the same shall accordingly stand dismissed. The writ petition is dismissed. In the result, the judgment under the appeal is set aside, and the writ appeal is allowed without any. So this says that writ petition is dismissed, writ appeal allowed, and said that there is no stigma, nothing, and the doctrine of pleasure is very clear. Now, Lordship, in this case, Lordship, this 2001 2 SCC 441 was relied on. It is very relevant, Lordship, because this is the judgment whereupon this doctrine was taken, Lordship, even the quoted, Lordship. This 2001 2 SCC page 441.
2001 2 SCC 441.
Lordship, the Lordship will get the fact at para 2. The fact is at para 2, Lordship.
2001
At page 443. Page 443. May I read, Lordship?
Yes.
This appeal, the appeal raises the following question. Whether Section 6 of the Nagpur Improvement Trust Act 1936, hereinafter referred to as the Act, confers power on the state government independent of the power of the state government under Section 10 to remove the trustee appointed under Section 4(1)(e) at the pleasure of the government, even before the trustee concerned complete the period of 5 years, as in our case. Lordship, now we come to para 7. Lordship, I can read the para 3. This. Lordship, the para 3 as 50 above, Lordship, it is just below the precedent D. Section 6 specifies about the term of the chairman and the trustees appointed under clause E of subsection 1 of any trustee shall have 5 years, and both the chairman and such trustee may be removed from the office of the state government at any time before completion of such term. Then, Lordship, the 4(1)(e), 4(2) is quoted, and the Lordship will see the 6. The term of the office of chairman or any trustee appointed under the clause E of subsection 1 of section 4 shall be 5 years, provided that the chairman or any trustee may be removed from the office of the state government at any time before the completion of first term. As in our case, Lordship, I'll read from our year, this 2023, very clear on that. So the Lordship at any time before the completion of such term, then para 10, the state government may remove from any trustee other than the ex officio trustee, and the all of us there. Then Lordship, please come to para. Submission. Lordship, please come to para 8 at page 446. May I read, Lordship? Para 8, third line, just precedent C, Lordship. Having considered the submission of the parties and after using the language of the section, we have no hesitation to hold that the field of section 6 and section 10 are separate. The removal spoken under section 6 is removal without any stigma, while the removal under section 10 is removal with the penal consequences as a stigma. If the submission of the appellant is accepted, by section 6 embodies section 10 lays down the condition procedure to remove, then removal of trustee would only be for penal and act the section say as section 10 covered in such cases. It is significant for removal under section C is confined only to such trustee who are covered under the clause E of subsection 1 of section 4, who are also nominated, as in our case, Lordship, by the state government. Now, Lordship will take note of this line. I'll read. Right of trustees falling under the aforesaid clause E are right created under the statute, and hence that very creator can always limit or curtail such right. This is my case, Lordship. This is my case, Lordship. Then, Lordship, the last line, in the absence of any other right under the very nature of the Constitution of India, such trustee cannot claim any right based on the principle of natural justice.
Either regulation or rules.
In our case, Lordship, these things are not there even. UGC regulation is the removal is silent, Lordship. Nothing is there, Lordship. Now, Lordship, may please come to para 11 at 447. Once the doctrine of pleasure is applicable, neither the principle of natural justice will step in, nor any question of giving any opportunity before removal would arise. There some Supreme Court judgment has been referred to. This Om Narayan Agarwal and Nagarpalika Shahjahanpur. I have a copy of that lawsuit. I'll not read that lawsuit. Also referred to.
Para 13 very important.
So, Lordship, now keeping all this, I'll come to para 13 at page 447, down below, Lordship, place it on H.
Very important.
This is the crux, Lordship. The learned senior counsel for the appellant tried to distinguish this case by submitting that the doctrine of pleasure was incorporated in the section itself. In our opinion, in our case, there is nothing, Lordship. Still, I am showing from this
regulation. It's not.
This is the, because my learned friend is referring to regulation. So regulation, there is nothing, it's silent. In our opinion, this does not make any difference. This does not make any difference. It may be in this case, doctrine of pleasure is explicit, but if no another statute, it is implicit, which we have held in this case, the same principle will be equally applicable. Accordingly, we do not find any merit of this submission. Even if it is there, then also it is equally applicable. The doctrine of pleasure. This is 1994, 2 SCC.
No, this is a new decision referred by you.
Yes.
This is a new decision referred by you.
Yes.
No, yesterday, or no, day before yesterday, you have been asked to reply only upon the judgments referred by him.
Yes.
So are you supposed to reopen the matter again?
No. No, if Lordship do not want to, this is the only thing, Lordship, this para 18 and 20, Lordship can see. This is regarding all the standing council and the state standing council and whether can, because they were appointed for a time. Lordship only para 18 and 20, I know. 18 to 20, Lordship. Para 18. So, Lordship, with all these, Lordship has read it, what my learned friend has shown, I have considered all these, Lordship. The judgments are there and the other judgment has helped me. And Lordship, only thing, Lordship, because the stay order, Lordship, the principal knows after the Siliguri municipality, Now, Lordship, it is very clear, Lordship. In the judgment, Lordship, it is regarding what is the balance of convenience, Lordship. It is the balance of convenience is we are suffering. What he will suffer, Lordship. Time and again, yesterday, he said, I am not a person not dying to occupy the post. I am not a person that I am dying to occupy the post.
You're not dying, then why?
So he repeatedly, for 3 times, Lordship, I have written in a document, 3 times he repeatedly said that my client is not dying for the post. He said repeatedly. If he is not dying, this petition is not maintainable, Lordship. If someone is dying, then only this 226, Lordship, otherwise not. If his client is not dying, Lordship, then why he has come for a writ petition under? That is what on the first day itself, when I moved the application, I put my hand at my ear and I said, I will not take the name of the petitioner because he is a man of such stature that I do not want to take his name. And I thought that once I file the application for vacating the stay, he will not come because he is not dying for this post. A person of his stature, he is not dying for this post. I thought that he will not come. Now, because he has come, Lordship, I have to argue all this, Lordship, because otherwise, day one itself, Lordship, I said that his education qualification, everything, Lordship, I have nothing to say. I have nothing to say. And I have not disputed, Lordship. I have not disputed, Lordship. With that status, Lordship, if he is not dying for the post, then writ petition, Lordship, sorry.
No, today we are only on this IA.
So, Lordship, I said that before the interim order was passed, respondent number 6 has taken I have given the document and the respondent number 6 advocate has appeared. They have already given the document, Lordship, on that day meeting, what happened, Lordship, on 28th. All this, it is on the spiral binding, Lordship. You can see, after the meeting, they have taken all the decisions, Lordship. So, now the college is suffering because neither the president, the petitioner is here, neither the respondent number 6 is here because of the order of the court. So, balance of convenience is in my favor. Because as a college, Lordship, the public interest is there, students are suffering, professors are suffering. So, this is the thing, Lordship, that before the court's order, the respondent number 6 has taken the responsibility, and these are the decision on 28th meeting, Lordship. And all these has already happened. It goes out, Lordship, to all the authorities. So, under that circumstances, Lordship, the interim order should be modified. In view of the only thing, Lordship can see this Siliguri municipality. It is the always, Lordship, para 4 Siliguri municipality is very clear, Lordship. That
Can a stay be granted?
when is stay to be granted, when to stay to continue and all that, Lordship, because Lordship, I will not take your Lordship's time, Lordship. It is the para 4, Lordship. In the last page, 439.
Acha, Mr. Mohanda, you tell me
Yes.
Whether you have made any averment in your writ petition
Yes.
that before filing of the writ petition, before 1 month,
Yes.
the respondent number 6 has taken charge of the presidency.
My lord, in fact, in my objection to the IA, my lord.
No, I am asking you whether you have made any averment in your writ petition or not. And
Regarding to what?
during submission, you have made any such submission before the court?
Before the court, my lord.
Yes. And also in the writ petition, did you mention it?
I'll just check. Lordship, give me a moment, my lord. I'll just check. One moment. When it was, I've been instructed, my lords, when the writ petition was filed, the private respondent did not join. But let me check, my lord. But that is not the, I'll come to that, I'll just check.
When he is looking at the document, only one thing, and page 27 of the repetition, that para 21, as usual, Lordship, there is a paragraph, that the petitioner demanded justice and the same has been denied. Let him show, Lordship, one single document that he is referred to, that he has written something to the Director of Higher Education, something with the Secretary, nothing, Lordship, not a single document.
Yes, my lord.
In all other cases, he has referred, there was representation was pending, all that is clear. In this case, nothing. And Lordship, this paragraph is a vague paragraph, Lordship, no document enacted, nothing. That the petitioner demanded justice, the same has been denied.
My lords, when the writ petition was filed, my lords, I can say it with some authority, my lord. The writ petition was filed on 19/08/2025. The respondent number 6 had assumed charge on the next day, 20th. But that is not material, my lords. My learned senior friend has distinguished the 3 judgments, my lords. I'll very quickly, my lords, give a reply to that, my lords. First, Makhon Pegu, my lords, that division bench judgment, my lords.
No, that judgment was referred by you. You are not.
Yes, no,
supposed
no,
to
it has been
give
distinguished
reply
by
to the
learned
same.
friend. I'll just give a reply, my lords. That judgment was very selectively referred, my lords, the paragraphs, and in all the paragraphs where the word tenure has been mentioned, that was not read, my lords. Now, my lord, this proposition of law, my lords, that, my lords, doctrine of pleasure, in cases of doctrine of pleasure, there'll be no natural justice. I agree to that, my lords. In fact, I agree to that, my lord, that's a settled proposition. But that is subject to an exception, my lords, which is tenure, my lords. Like, Lordship, may kindly take up Makhon Pegu just for a moment, my lords. My learned senior friend has read all the paragraphs.
No,
but in
that is the judgment you have referred to.
No. I referred to the judgment, my lords. Now it was distinguished by my learned senior friend, my lords. He read out the judgment again, and he said that in matters of doctrine of pleasure, natural justice won't apply. But those paragraphs were skipped, my lords, where the judgment says that there is an exception to it. The exception is that where there is a tenure attached to the statute. That was not read. Lordship, may kindly take up just for a moment, kindly Makhon Pegu, my lords, the division bench judgment, my lords. That was not read because that cannot be distinguished, my lords. All the paragraphs are read, my lords, but none of the paragraphs, my lords, where the word tenure occurs, my lords, that was not read, my lords. Lordship would come to directly. What was the question here, my lords? The question was whether missing autonomous council nominated members could be removed without a show cause notice. The court held yes. Why? Because there was no tenure attached to that act, my lords. Now, Lordship would come to paragraph 6 directly. I'll just reiterate once, my lords. A bare reading of the provisions makes it clear that the government is duty bound as soon as possible to take steps for constitution of an interim council, so and so. Lordship, may kindly skip few lines. Nomination so made to the interim general council or the executive council is not for any particular period. It does not assure any tenure as such. Does not assure any tenure as such. They obviously hold so and so. Now, my lord, may come to the next paragraph, my lord. Paragraph 9 for a moment. Next page. It has been reiterated by the division bench. Paragraph 9, my lords. I'll read it slowly, my lords. The writ petitioners were nominated as it is evident from the order dated so and so. The governor of Assam, while reconstituting the missing autonomous council and the missing autonomous executive council by replacing the early one, they had not been appointed for any particular tenure. Now, admittedly, the tenure prescribed by the regulation is 5 years. Now, my lords would again come to paragraph 11. Paragraph 13. These paragraphs are not read, my lords. It is settled law that the pleasure doctrine relates to tenure of a person to public office. Tenure means manner, conditions, or term of holding something. According to Webster's third New International Dictionary, the term of holding, title, authority, according to the Oxford English Dictionary, it therefore means the period for which the incumbent of the office holds it. In the absence of any tenure to hold the office, my lord would kindly mark it, my lords. The office holder holds the office subject to the pleasure doctrine. Now, if a tenure is attached, my lords, doctrine of pleasure would not apply, and therefore the principles of natural justice cannot be given a go by. That is my contention, my lords. And that has been expressly held by the division bench. And now the Supreme Court judgment, what my learned senior friend has referred, my lords. Few paragraphs, it was not read in context, my lords. I have this judgment, my lords, in my mobile phone, just one paragraph I'll show, my lords. In what happened in that case, my lord, is it not even applicable? Let them say there is no tenure attached to my post. Just because it was relied in some judgment, it was relied in some context, my lord. 2001, 2 SCC 441. Now here what had happened, my lords, those nominated members were removed in terms of a clause in the regulation or the subject rule. Lordship would come to paragraph. In paragraph 3, section 6 has been quoted, my lord. My lord would see section 6. My lord has it, my lord. The term of the office of the chairman of any trustee appointed under clause E of subsection 1 of subsection 4 shall be 5 years. There's a tenure attached, but however, my lord, there's a proviso that provided that the chairman or any trustee may be removed from the office of the state government at any time before the completion of such term. My regulation does not have such a clause, my lord, that before term I can be removed. And it was under this context, if my lord comes to paragraph 13, my lord. Just a moment, my lord. I don't have a copy of the. Yes, paragraph 10. Paragraph 10 of the judgment, my lord. In the present statute, section 6 refers to the trustee falling under so and so, so and so, so and so, and refers to clauses of removal of the no stigma has been obviously because rule 6 or section 6, in that case, there was the power, my lords, that the members could be removed mid-term. It says it shall be for 5 years and the government may reduce the tenure. But such a clause is not there in our regulations, my lords. Now coming to the third, my lords, judgment, my lord, Jogendra Nath, my lord. My learned senior friend has placed a review petition judgment, my lord. My lord, subject to correction, my lord, may kindly take it up. I don't think it will be a binding precedent, my lord. My lord would see, take up the review petition and take up the review petition, the first page, page 2, and the last paragraph. Both, my lord has it, my lord. Both MSP Bhattacharya, learned counsel for the review petitioner, and Mr. UK Nair, learned counsel for the respondent number 5 in the writ petition, agrees to the proposition. Now, whatever direction was passed by the honorable court in the review petition was a consent decree and a consent order that cannot be considered as a binding precedent, my lord. How can it be considered as a binding precedent, my lord? With the deepest respect, my lord. Both the parties have
May not
agreed.
be, but the order passed in the
And
WPC was reviewed.
Yes, no, not WPC was not a review. WPC order, it was reviewed. In the review petition, my lord, Jogendra Nath Sharma's case, what had happened? There was a Jogendra Nath Sharma approached the Guwahati High Court saying that my term was curtailed mid-term without show cause notice. Honorable Justice Bujor Barua held that no show cause notice ought to have been granted. Now a review was filed, my lord, where in the review petition initially the ground was taken that someone has joined the post. That was not, in fact, it was a case of review. When the review was finally decided, there was no decision on any facts. There was no finding. It's a order which is an agreed consent decree, my lord. There was an understanding between the parties saying, okay, this would do. I'm agreeable to that. Now, how can this be a binding precedent, my lord? And in any
May
case,
not
just
be,
one more.
but in view of the order passed in this review petition, whether the order passed in the WPC remains.
Yeah. Oh, that is something academical. I don't know as of now. I have to apply my mind to that, my lord. But my lord, in any case, in a court exercising powers under 226, whether the court does not have the power to pass an interim order. And one more last submission, my lord, I'll conclude, my lord.
No, that is not the issue before
Yes,
the court.
yes.
Whether court can pass interim order
I
or
know.
not. That is not the issue.
I know, my lord.
Then why you are arguing on that point?
No, I'm not. I'm just sorry, my lord. My apologies for that. No, one last submission, my lord. Kindly, just one. I'll conclude after that, please. Now, my lord, the other side is harping on the fact, my lord, that the 2001 rules are applicable. Also applicable because, and there's a point there, my lord, that non-political and political thing is there, my lord. Now, my lord, like I submitted the other day, my lord, that the present Demoria College is a autonomous college, and to be autonomous college, the regulations has to be followed. This is the order granting autonomy, just one page order. my lord.
No, on the other day you have shown it.
Yeah, no, this I didn't show. So no, just one page.
No. One order was passed before this court to show that the Demoria College and Dhokwakhana College are two autonomous.
Two autonomous college. And now,
Autonomous college.
if my lord takes up the regulation of the UGC under which autonomy has been granted, what does it say? Consequences of violations of the regulation. Consequences of the violation of the regulation. It says the autonomous college shall at all times adhere to the UGC regulations and guidelines made and issued by the commission from time to time, failing which the UGC may take appropriate action against the defaulting autonomous college, including revoking the autonomous status. Now, my lords, if the college
I do not know.
How can
Page 30
2001 is applicable, my lord?
Page 30 of my application, Lordship, time and again saying. Page 30, what I have written in my application. Yes, these are wrong statement made before the court.
2000
Again, again.
2001 rule has been,
Please come to page 30.
sorry,
Third line, under both UGC regulation and the 2001 rule, the power to nominate a ZB president reside with the state government. First, then Lordship, ground 4, for that 2001 rules and UGC regulations are required to be harmoniously construed.
yes.
I specifically made statement. Lordship.
I'll reply
When I
to
say
that one.
UGC regulation, I've enacted the UGC regulation. How come I'll say that the UGC regulation is not applicable? Why this statement is made, Lordship, time and again before the court? This is something, let him show from my application that at least one line I have said in my application that the UGC regulation 29(4).
My lord,
Somebody
2000,
should be very careful to make
2001 regulation, with the deepest respect, has only been exported in this case because there is this term of political person. Now, how come two rules can apply, my lords? This UGC regulation is under entry 66 of list 1, my lord, central list.
I'm grateful, Lord.
I'm deeply obliged. My lord will also consider disposing of the entire in that case. Now, if my lord is thinking. Provision.
No provision. No provision. No provision. Lordship, after this 2011 Supreme Court judgment, where is the question of giving so cause, Lordship? The Supreme Court is very clear, Lordship. Now, I have given 5 judgment, Lordship, on that. There is no so cause. No so cause. At the when there's Lordship, there is no so cause.
From AK Kripak, my lord, I don't want to reiterate. Even if it is not there, it has to be read into it, my lord, in the statute. Rules of natural justice, my lord. That is it. One, my lords, and the petition.
Name of? The same chamber, Lordship, and Dr. Lordship. You are learning. He teach me that. Always call the advocate of the other side, then you will get the whole thing. Then only I get this, Lordship. Otherwise, from the online, no.
Makhon Pegu was argued by my senior, he lost, my lords. And Dr. was
We have learned that from there because that time also online was not there. I'm
very
grateful.
grateful. I'm very grateful, man. Deeply obliged, man.
Obliged.
Patient here.
Timing item 6.
So, Lordship, a happy holiday, Lordship. For last 2-3 days. Yes, yes, tomorrow, last day, Lordship. Yes, yes. Yes. No, 18 it is 18 it is already there, Lordship, that for taking the action for suspension and all that is the other rule, 64 rule. In the new rule, 18, rule 18 is clear, Lordship, that for all other purpose, it is the 64 rule. Tomorrow, Lordship, at 2, Lordship. Or there is a injunction letter tomorrow, Lordship. I have to argue last day. Second half, Lordship.
Timing item 6.
May repose. Regarding this matter,
regarding my lord, payment of dearness allowance to a contractual teacher. So on other day, my lord was pleased to refer the judgment of Jagjit Singh. Yes, my lord, regarding parity of pay. Because we are denying their dearness allowance from 2017. Because we have given them the benefit when we have issued the notification from the administrative department. Initially, state government employees was given from 2017. But in case of contractual employee under SSA and state pool, we have issued after 2 years. So from that day, we have given the benefit. So my lord was pleased to refer the case of Jagjit Singh, my lord, whether it is applicable or not in that case. How can we overcome the ratio laid down in the case of Jagjit Singh? So in that regard, my lord, I have referred one judgment, my lord. I have given it. It 2019. Number to my police. 2019-18 SCC, my lord. State of Bihar versus Bihar Secondary Teachers Struggle Committee, Mungar and others. Here also quite. Page number 301. Facts are otherwise quite similar, my lord. In Bihar also, my lord, there are two categories of teacher. Due to lack of qualified teacher, my lord, they introduce a new rule, my lord. And under that rule, my lord, they have appointed some additional teacher. They are called as Newsit teacher, my lord. Newsit teacher. Their name was Newsit teacher. In our case, my lord, it's a contractual teacher. So their salary and the teachers who are the original teachers, my lord, under the previous rule, their salaries are different, but their work are similar. In that case, my lord will find at paragraph 40, my lord will find the difference between the Newsit teacher and the teachers under regular cadre. Paragraph 40, my lord. When the matter was taken up for consideration by the division bench, it was submitted on behalf of the writ petitioners that both categories of teachers, government teachers and Newsit teachers, were imparting instruction in the same nationalized school, and yet there are considerable difference in emoluments paid to Newsit teachers. That both the categories of teachers were discharging same responsibility and were teaching the same syllabus, and there was no difference in the performance of their duties and responsibilities. That the distinction made between these two categories was completely unreasonable, and that on the basis of constitutional principle of equal pay for equal work, Newsit teachers were entitled to same salary, pay scales, emoluments as were payable to the government teachers in national schools. Strong reliance were placed on the decision of this court in state of Punjab, Jagjit Singh, particularly paragraph 42 and 44. Next, the stand of their government, state. While defending the action on the part of state, the learned Advocate General submitted inter alia that writ petitioners were appointed under the provisions of 2006 rules, and as such, they could not challenge the validity of the rules under which they were appointed. That the teachers appointed before 2006 were appointed by the director in recommendation of Vidyalaya Seva Board, Bihar Public Service Commission, subordinate Service Selection Board, whereas Newsit teachers were appointed under completely different set of rules. That the teachers appointed prior to 2006 was a dying and vanishing cadre, and there were no fresh appointment in that category. Thus, the Newsit teachers could not claim any parity on the basis of equal pay for equal work. So this is the case, basic case, my lord. Now, my lord will find the findings of the Honorable Supreme Court, paragraph 104, my lord. 104. If a pay structure is normally to be evolved, keeping in mind factors such as method of recruitment and employer's capacity to pay, and if the limitations or qualifications to the applicability of a doctrine of equal pay for equal work admit, inter alia, the distinction on the ground of process of recruitment, the stand taken on behalf of the state government is not unreasonable or irrational. Going by the facts indicated above and the statistics presented by the state government, it was an enormous task of having the spread and reach of education to the remotest corner. Furthermore, the literacy rate of the state, which was lagging far behind the national average, was also a matter which required attention. The advances made by the state on these fronts are quite evident. All this was possible through rational use of resources. How best to use or utilize the resources and what emphasis to be given is to be given to which factors are all policy matters, and in our considered view, the state had not faltered on any count. As laid down by this court in the decision of Joginder Singh and Jabbar Singh, the state was justified in having two different streams or cadres. The attempt is making over process of selection of Panchayat Raj institutions and letting the cadre of state teachers to be a dying and vanishing cadre were part of the same mechanics of achieving the spread of education. These issues were all part of integrated policy, and if by process of judicial intervention any direction are issued to make available same salaries and emoluments to the Neojit teachers, it could create tremendous imbalance and cause great strain on budgetary resources. So, my lord, similarly, in our state also, my lord, to overcome the strength of elementary school teachers, my lord, a cadre was created under the RT Act, after an enactment of the RT Act. Under the SSA, my lord, there are some contractual teachers were appointed. Subsequently, state government also appointed some contractual teachers, my lord. Subsequently, they have been given the benefit of pay parity. But while granting the dearness allowances, my lord, in respect of the state government employee, that notification was issued in the year 2017. But in respect of contractual employee, the administrative department given that benefit on a later stage, my lord. And this judgment is squarely covered our stand, my lord. Yes, my lord. Yes, my lord. Yes, it 2017 matter, my lord. In fact, my lord, they have placed reliance on the reference is there, my lord. Yes, reference is there, my lord. But only only thing is in respect of this case, my lord, it is not the case that we have not given the same pay parity. We have given them the same pay parity. In respect of only dearness allowance, that allowances was granted by the notification of the finance department to the state government employee. And that was adopted by the administrative department on a later point of time. And from that day, my lord, benefit was given. So, my lord, there is no, because we have to think about our resources also, my lord, while paying the emoluments. So, since the decision was adopted on later point of time, that is why on that day, the benefit was granted to the petitioners, my lord. In fact, that has been held in this Bihar case, my lord.
Now, your lordship, in Bihar case, your lordship, that case, there is a deliberate decision on the part of the government to keep these two batch of teachers, your lordship, separately, your lordship, two cadre of teachers. Here, your lordship, the government itself has taken a decision. The benefit that is entitled to the regular teachers will be paid to us, your lordship. After that, your lordship, that is the distinguishable feature of that particular case, your lordship. And your lordship's judgment, your lordship. Read it, yes. It was reported in this month's GLT that your lordship, Rafiqul Islam, your lordship. 2025 6 GLT 810.
Rafiqul, no?
Your lordship have extensively referred to Jagjit Singh to grant your lordship pay scale to a lecturer, your lordship, assistant professor, tutor professor, your assistant professor, your lordship. And your lordship, para 25, your lordship has succinctly held, your lordship. May I read your lordship, para 25? Final finding. In the case in hand, indisputably, the petitioner has been rendering services more than 20 years and indisputably, the monthly salary of rupees 5,200 per month. On the other hand, his counterparts are receiving regular scale of pay as held in the case of Jagjit Singh. The sole factor that requires for determination is whether the petitioner is rendering similar duties and responsibilities as were being discharged by regular employees holding the same corresponding post and applying the parameters laid down in paragraph number 42 of said decision. This court is satisfied to hold that the petitioner has been discharging the similar duties and responsibilities like those of regular lecturers, and that being so, the principle of equal pay for equal work as summarized by the Honorable Supreme Court in paragraph 42 above is clearly applicable in the present case. Thus, this court is considered opinion that now that is what your lordship has held on the basis of your lordship Jagjit Singh. This is the same case, your lordship, where we are discharging the similar duties, your lordship. There is no dispute about that, your lordship. And thereafter, and after taking a decision to pay the equal benefit, your lordship, they cannot now turn back and say that we will not pay. No, we are not going to pay you since you are not regular. This is my humble submission. And in fact, your lordship has since extensively referred to Jagjit Singh. I am not lordship. Only thing, your lordship, one more judgment your lordship will find. One line of that your lordship has, on last occasion, your lordship has your lordship has referred to Rayappa judgment, your lordship, 1971 Constitution bench. Rayappa, your lordship, V. Rayappa. One para I am relying on, para 85, your lordship. I will hand over the copy, your lordship. I will just read out, your lordship. In para 85, last line, your lordship, last part, Article 14 and 16 strike that arbitrariness in state action and ensure fairness and equality of treatment. They require the state action must be based on valid, relevant principle applicable alike to all similarly situated. And it must not be guided by any extraneous and irrelevant considerations. All similarly placed, all situated alike must be treated similarly. That is the, your lordship, what Article 14, your lordship, enforces, your lordship. Lords.
On the similar line, my lord, I would like to place another judgment, my lord. I have earlier handed over a copy, my lord. 2009 9 SCC 514. That copy has been given, my lord.
Lordship, deeply obliged.
Obliged.
For hearing, item 34.
On the last date of hearing, the counsel for the respondent has informed the Honorable Court that the respondent has been expired, for which I have already moved an application regarding implementing the legal heirs of the respondent. I have filed the application on 8th of December 2025, but it is pending before the registry as the copy of this application has not been served to the opposite counsel. However, it is the will of the legal heirs of the respondent whether they want to appoint the same counsel or not. So it is my humble request, at least notice should be issued to the legal heirs so that they may be implemented and they may appear before the honorable court. Mr. Kabra, proxy counsel for Mr. Kabra has appeared and she had informed that the that the respondent has been expired. Because the copy has not been effectively served to the opposite counsel. It is the will of the respondents whether they want to appoint the same counsel or not. Because after the expiry of the respondent, he has no authority to represent the respondent. So it is my humble request that notice should be issued in this appeal. And out of the contest, I would like to mention that during the proceedings of the this appeal, sir, some known person of the respondent, along with the defendants in the main suit, has applied demarcation case before the circle officer, and circle officer has issued me some notices regarding the demarcation, and I've appeared before him on 17th. Still, he is adamant that I will demarcate the property. In that, whole the proceedings regarding RFA, my adverse possession, and the orders of the London Trial Court that the property belongs to the partnership will become infructuous. If honorable court thinks can use the inherent powers in the present appeal, at least status quo orders be passed, because again he has issued notice to appear on 22nd of December. Yes, sir. And I have having the notices from the circle officer. Sir, regarding the property, because already as per their admission before the London Trial Court and before the present honorable court, they are admitting that I am in the possession and I am claiming adverse possession. If demarcation will be done by the circle office during the pendency of the appeal, my appeal will be infructuous and I will be dispossessed. I have filed he is not going through the objections. He is saying I will demarcate the property. My appellants have appeared before him. I have already drafted the objections and filed before the circle office. Still he is continuing with the proceedings. I only need status quo till the next date or till the appearance of the respondent. He will appear and explain the situation. I am having the copy of the objections I filed before the circle office along with his notices regarding the demarcation of the property. I am still in the possession. It will be regarded as dispossession during the proceedings of the honorable court. I am having the original notices with me. There is no prayer for stay application because no proceedings has been initiated by any of the respondents or other defendants. Subsequently, yes, sir, under the emergency situation, I am requesting the honorable court for inherent powers only regarding the status quo. I am not requesting the honorable court for any stay of the proceedings or litigations or anything, only status quo, because they want to dispossess me during the proceedings before the honorable court. The honorable court may issue notice because I have moved an application notice to all the defendants because they have already moved application before circle office regarding the demarcation that they are the absolute owners of the property.
So there was a direct spot. Operating on record the legal representative of the respondent But does it is that you put that as sit, then not be listed for this work as a copy of the say things of not be served of the object for the understanding. That we of the matter is a sort of that this is this what is the issue all the respondents. All the respondents. According to is provided that
May I submit some? Were the defendants in the main suit who had, along with the present respondent, applied regarding the demarcation. I was also one of the defendant. I have moved an application under the 7 Rule 11 A, B, and D against the suit of the earlier respondent who has been expired. And my application was allowed, along with the counterclaim has also been rejected. And her main suit. I want to issue the notices to the other defendants because they have moved to the demarcation court. They are not party before the Honorable Court. That's what I'm saying. Because it was my case regarding adverse possession. They are not claiming adverse possession. Final judgment has been passed by the London Trial Court that it is a partnership, property belongs to the partnership. Still, they have moved, and the name of the respondent who has been expired is also there regarding the demarcation. The Honorable Court cannot issue, but the name in that demarcation application has also been mentioned regarding the respondent who has been expired. That's why he is taking that they have been authorized by the respondent. IA, yes. I just request the Honorable Court to use inherent powers regarding only status के because status quo क्योंकि because but the respondent's name is also there in the demarcation case. Circle officer, I am having the notices. I will move, but he is again and again calling the appellants on 22nd of December. There is no time and there will be holidays before the Honorable Court. That's why I am requesting the Honorable Court. I will try my best.
But yeah, so some notice is difficult to put forward not party.
But notice to the respondent should be issued by them regarding service. Highly obliged. Any January 23rd 23rd January. Holiday, sir. Yeah. 27th is Saturday, sir. 27th is okay. Highly obliged.